And I wanted,
Okay, so we now have a quorum and we'll begin the COPRAC meeting. This meeting is being recorded. Before I do roll call, we ask that anyone who plans on giving public comment to use the raise hand function at this moment. Now, with permission of the chair, I'll take roll call.
yes, thank you, Angela.
Okay. Benola,
Present.
Bacon, Bradley, Brown, Chivers, Fields,
Here.
Krieger,
Here.
Mark,
Here.
Mercado,
Here.
Munoz,
Here.
O'Reilly,
Here.
Poindexter,
Here.
Star.
Here.
Thank you. Okay, is there anybody in the public who would like to give a comment? Can you please use the raise hand function at this time? Okay, we have one public commenter, Deborah Wolf. Deborah, you'll have 2 minutes to make your public comment, and at the 10-second mark, please conclude your comments. One moment. Go ahead.
Thank you. Good morning. I previously had called in and submitted some documentation about the proposed opinion on the contingency fee conversion clause. Conversion clause and contingency fee agreements, I'm sorry. And I did not see that there were any revisions made to the opinion, but obviously the Consumer Attorneys of California still has concerns, as we previously stated.
Thank you, Deborah. And just for your information, that particular opinion will likely be discussed at the next COPRAC meeting. Unfortunately, we're not going to be able to get to it at this particular meeting.
Okay, thank you. Well, I will come to the next meeting, then I'll look for any revisions that are made. Thank you.
Thank you, Deborah. Are there any other public comments? Please use the raise hand function. Okay, I don't see any more public comments.
Okay, great, thank you. And I wanted to just start the meeting by introducing our new COPRAC member. And I feel bad because we haven't had a chance to do a in-person or even a virtual orientation yet, which we will do before the next meeting, but with the holidays and everything, it was just difficult scheduling. But I wanted to introduce Vakita Poindexter. And I know she's a business professional. She has a background in human resources, but I will let her kind of give a little bit of an introduction if she would like. And I just wanted to welcome her. And the other thing I wanted to say, Vakita, as we discussed, our agenda is kind of light today because we need to focus on one particular issue. But if there are opinions you see on the agenda that you're interested in the assignment agenda or the agenda, just please let us know so we can try to get you assigned to the working groups for some of those opinions.
Okay, perfect. Thank you, Madam Chair. And Sarah, I'm sure we'll catch up sooner or later, but thank you. So it's an honor and privilege to be a part of the committee. Again, like she said, I'm Vakita Poindexter. My background is in human resources. I run a human resource consulting firm that's located out here in beautiful Temecula, California. Finally, we're getting some sunshine. We're celebrating 23 years in business. So looking forward to being a part of this committee and working with each and every one of you.
Okay. Thank you. Now let me. So I think the next on the agenda that I wanted to do is do the approval of the meeting minutes before we do an administrative staff update. So would someone like to move for approval of the meeting minutes from our last meeting?
I'll move to approve.
I'll second.
Okay, we'll take the vote to approve the minutes from the December 2nd meeting. Bacon, Brown, Bradley, Chivers, Krieger,
Approve.
Mark? Mercado?
Abstain.
Munoz?
Approve.
O'Reilly?
Approve.
Poindexter?
I'll abstain.
Star?
Abstain.
Benola?
Approve.
Okay, so we have 4 approves and 3 abstains.
And I think at this point, I wanted to allow some time for a staff update or administrative comments. So I don't know if Erica, you want to take the lead, or someone else from the State Bar would like to take the lead on that.
Sure. So I'll go ahead and start, and then Randy's going to take over for a moment as well.
Okay.
Good morning, everyone. So not a lot to report today. We are just a brief update on some of the work that COPRAC has worked on in the past and is now pending with the Board of Trustees. So that includes the civility rules, as well as tangentially the attorney oath. So those are both currently in the public comment period. As of right now, the public comment period on those items is set to end on January 30th. However, at next week's Board of Trustees meeting, the board will be considering whether or not to extend the public comment period on those items through March 1st. So I can update the committee if that does occur and when it does. We have received some public comment to date, or the board has received, excuse me, some public comment to date on both of those items. It is interestingly somewhat split. I can kind of give more information on that if the chair would like, or otherwise we can provide a summary once the public comment period has closed, whatever your preference. Oh, you're on mute, Sarah. I'm sorry.
Sorry, I was saying maybe just a very high level summary would be great if you could provide right now.
Sure, yeah. So very high level, what we've received is on the oath, we've received 23 comments to date. Majority of those commenters have identified themselves as attorneys, as well as 2 comments from organizations. The Civility Task Force has commented they're being considered an organization, as well as the Beverly Hills Bar Association. So far on the oath, 9 agree, 1 agree if modified, and 13 have been against. Those in favor have said that it'll level the playing field and that it's a necessary change. Those against have said that there are interpretation issues with what civility is, and it may not change behavior, and that there's the penalties for non-compliance they disagree with. On the rules of professional conduct, we've received 18 comments. The majority, again, have been attorneys so far, and then CCTF and the Beverly Hills Bar Association both gave public comment. 6 agree with the proposal as is, 3 agree if it's modified. The modification being proposed by the Civility Task Force and a couple others is to limit the rule to the practice of law itself. And then 9 have been against the proposal. All of those were either individuals who indicated that they were attorneys, or they declined to state whether or not they were attorneys. General themes in the comments that we received so far that are against the proposed rules are that there are possible First Amendment concerns, that the rule is somewhat vague, it could be subject to abuse and lead to more complaints, and that it could inhibit the zealous advocacy on behalf of a client. So things that I think we all kind of anticipated to see in the public comment. And then I don't have anything else to report at this time, but I'm gonna hand it over to Randy, and always able to take questions if there are any.
Thank you, Erica, for that update.
If there's no questions about that, I just wanted to give a very brief staffing update for the Office of Professional Competence. I wanted to announce that effective February 10th, that I will be retiring from the State Bar of California, and that Erica will be assuming the duties as the Director of the Office of Professional Competence. And I think that's all great news. Erica has demonstrated in the last few months that she not only can staff COPRAC, but also has the leadership temperament and acumen to actually lead the entire office. And I look forward to the new path that she's going to chart for the Office of Professional Competence. It really has been a privilege to serve the State Bar, and working with COPRAC has been one of the major high points. I note during the roll call, Joel's enthusiastic response when his name was called. And I think that's very representative of how many feel about COPRAC. Enjoy your time with COPRAC. It goes fast. It's rare that you get a chance to do it again. It's one of the most rewarding things you can do. There have been prior members who've sought to be reappointed, but sometimes that is difficult. And so you're in an exciting time working on things like civility and the duty to report, possibly circling back to the duties of prosecutors and conflicts. And you even have a new section on your agenda for emerging issues that I imagine will have all sorts of interesting and exciting things for COPRAC to do. Also, I encourage you not to take COPRAC for granted in the grand scheme of the regulation of the profession in California. Guard COPRAC because it's an important function. And again, just enjoy your time, and thank you for the privilege of working with you. I've made a lot of good colleagues and even some longtime friendships with the members of COPRAC over the years. And I wish you all well. You're in good hands with Erica. She will be great. I think she's a better manager than me that I've discovered in the last few months. So look forward to that. Thank you.
Wow. Randall, I just want to say thank you. I mean, we met 100 years ago. I've gotten older and you haven't, but it's been a real pleasure working with you over the years. And I wish you all the best. Where are you going?
I'm retiring.
Well, good for you. Good
Sail
for
off
you.
into the sunset.
Well, good luck to you.
Thank you, Joel.
Yeah. And Randall, we are going to greatly miss all of your valuable contributions throughout the year. So I also wanted to just thank you. Although I also am excited with working with Erica. It's been great working with her for the last several months. And so you both have been amazing. So I appreciate it. Thank you.
Thank you, Sarah.
So I wanted to, looks like we're doing well on the schedule. The next item on the agenda is the lawyer as expert draft opinion. And I can take the lead on that discussion. Most of the revisions since the last meeting were at the kind of towards the end where the highlighting appears. And I'll go over those revisions. And we had a discussion. I know this is dealing with the last scenario. So the last scenario in the lawyer's expert opinion was where the law firm is representing a client in a completely unrelated matter. At the same time, the expert is testifying against that company client in an unrelated matter. And I'm going to pull up it's hard for me to follow along. I'm just going to pull up my version really quick so I can find exactly where it is. So it's line 276 is the one I'm looking at on, saying even though scenario 3 does not implicate conflicts of interest. Oh yeah, so it's up on the screen, sorry. It was, so this was the new language added, although the one thing I forgot to do in making this edit that we should add, at the end, I think there should be a CRPC 1.4B, because that's the rule. And this edit was based on a discussion at the last meeting, in part comments by Justin and also by Ken. Is Ken on the, I don't know if Ken's with us today. I think Ken had a conflict with today's meeting. He might have had an arbitration. I can't remember. But this was I think mainly in response to Ken's comment that he felt like this kind of disclosure might help fulfill the lawyer's duties under 1.4b to explain these particular risks, which is the fact that the expert only testifying adverse to the company in unrelated matter, and that expert's testimony may be given undue weight if the relationship is known to the jury because the expert is testifying against a current client. And this would help the company to make an informed decision regarding whether it wishes to continue with the law firm's ongoing representation. So I will just pause and see if there's any feedback on this particular addition, because this is one of the main additions where we're trying to address, even though we're concluding that 1.7 doesn't necessarily apply here, or 1.7b, dealing with material limitation conflicts, is there still some sort of duty of communication under 1.4? So what do folks think about this addition?
Well, I like it, and I had the same instinct as you to add a citation to 1.4 there. So we're on the same page. I don't recall if this was a controversial addition or not. But if not, I kind of like the idea of seeing what the public thinks about this concern that we've identified about in this scenario where the expert, is testifying against the firm's current client, and see if what the public thinks about our analysis on this one. That's really all I have on this.
And this was the main addition made. The rest of this highlighting, which, as we finalize it, we'll have to remove this. This just reflects our internal kind of comments from the last meeting and as part of the working group subcommittee. And I think Ken was also okay with this addition, which I circulated, was circulated among the working group. But if you could scroll down a little bit, this kind of goes into our discussion about you could scroll down just a little bit more, sorry. Okay, yeah, okay, so this is since Brandon, and I think others did too, raised a concern at our last meeting about, a discomfort somewhat with the conclusion that there's not some sort of duty of loyalty issue that might arise from this fact pattern. Although it's saying here 1.9, which is dealing with the rule relating to former clients, I think here it's a concurrent, the law firm is currently representing the client, and then the expert is at the same time representing testifying on behalf of another party against the company. So it's really 1.7 and the analysis of 1.7b, which is the material limitation conflict provision. And I don't know. It's the initials there are JM. I'm trying to figure out. Oh, Joel. Sorry, Joel. That was you. Maybe who I think at the last meeting you raised the Oasis West case that we should look at that for guidance.
Yeah, Sarah, that was more of a question than a statement. So
okay.
And I'm glad you looked at it. So
yeah. So we did go back and look at it, and my opinion after looking at it was, that was dealing with the opinion is based on the misuse of the client's confidential information and the attack on the lawyer's prior work, which I think is distinguishable from our facts where there's entirely unrelated matters without a risk of disclosure of confidential information. So I don't believe the reasoning in Oasis necessarily applies here. And it seems like the Commonwealth case, which we've referenced previously in this draft opinion, is more analogous. And the opinion right now is drafted agrees with that, the conclusion that was reached in that opinion, which is that this particular factual scenario would not raise a conflict under Rule 1.7b. I also went and did some more research and looked at some of the cases applying kind of the lawyer's duty of undivided loyalty. And in most of the cases, they always involve the concurrent representation and concurrent legal representation, where as opposed to our situation where there's, it's not this, the second representation is it's not a legal representation. The expert is, the lawyer serving as an expert. And the only exception is that American Airlines case, which we discussed kind of thoroughly in prior COPRAC meetings. And we also discussed in the opinion early on and distinguished that particular case where in that case, the lawyer was serving as a Rule 30b-6 witness and had a fiduciary duty, and there was a risk of disclosure of confidential information. So I'll pause here. I don't know if Brandon, if you've had a chance to consider further.
So I just want to say, I think this is really an excellent and reasonable approach. I still have this discomfort, and maybe that's just my problem, but I went back to the Commonwealth case. And one of the things in the Commonwealth case is that they seemed to emphasize or find important that one of the engagements was, if not terminated, in a state of inactivity or repose, right? And so that is different than our hypothetical. They're kind of viewing it. The Commonwealth decision does mention or lean into the fact that there wasn't really anything active in one of those attorney-client engagements, in the attorney-client engagement. So I think what you've done here is a totally reasonable approach. But I don't know that we're ever going to find authority dead on that says we don't have to worry about a violation of the duty of loyalty in an ongoing representation. I am very much looking forward to the public comment on this, just to see other points of view and see how it's received, because I think you've done a great job of navigating an intelligent path through these authorities.
Yeah. And I don't necessarily disagree with you, Brandon. I personally, have similar concerns about the duty of loyalty in this type of situation. And it's not something as a practical matter, or even as a client matter that I would feel comfortable with. But I just have a hard time under the language of the rule and the way it's been applied in the case law so far, that it really implicates the prohibition under the rule strictly. So I don't know, maybe the public comment will reveal some analogous case or make a good argument for why, if it does, they feel it does raise a loyalty type issue. So the other edits made were very minor, so I don't think we need to go over them. But I wanted to just open it up for kind of broader feedback if anyone else had a chance to review or had feedback to other sections of this draft opinion, but this was the primary substantive area. So. Since I'm not hearing anything, I'm wondering if I don't know if it's at the point now where we want to, and I welcome the working group to weigh in here, where we want to vote on it, whether to issue it for public comment. It needs to be cleaned up clearly because it's still in red line form. Or do we want to take some time and kind of carefully review it one last time and then vote on it at the next meeting? Anyone from the working group want to give your perspective?
I haven't reviewed it for language or proofing or anything like that. I've thought we need to make sure everyone's on board with it conceptually. Yeah. But if we took another till the next meeting to just make sure we're good with a clean version, and then maybe give everyone else an opportunity to spend a little more time with it, that might be a good approach.
I agree. That makes sense. And I too feel like I should, it should be proofed and read one more time in a clean version now that it seems like there's not opposition to the new language. So I propose that's what we do, that we table this and we'll come back with a clean version for our next meeting, and hopefully that the edits, any additional edits will just be minor, because I think we've addressed a lot of the substantive edits now, so it should be ready to vote out at our next meeting. And the next topic that I wanted to get to is just given that the ethics symposium is coming up in April and we've got to start planning well in advance, I wanted to kind of try to finalize the topics that we want to address at our next ethics symposium. And so I think this list that's on the screen now, my understanding is it's what members have provided input in advance. This first one, I think, is a definite one because it's one that we do. It's traditional to do it every year, which is more of it's similar to what's been done at least the last 2 years that I've been on COPRAC, where it's recent developments in legal ethics, professional conduct, what you need to know. And this is where we have an opportunity to discuss any recent COPRAC opinions or kind of any recent developments in the law governing lawyers. And so the part that the topics will include, this is something that I think we'll finalize as we get closer. But this typically is a leadership panel. So this would be Brandon, Justin, and me who would provide this panel. And the thoughts were to address civility, given that there's right now proposed new rule of professional conduct and the civility oath. And then the consideration of Rule 8.3, which is being considered. And then I think we have to kind of figure out which of the either draft or if there's any that are approved, recently approved ethics opinions that we want to also discuss on the panel. So there are 3 listed here, but I think we need to kind of, as a working group, kind of finalize which ethics opinions we'd want to discuss. And of course, we want to avoid any kind of overlap to the extent. I see the next one is cryptocurrency. So if that's something that we decide others want to address, we wouldn't include it in our leadership panel because there is a draft opinion on cryptocurrency now as well. So are there any feedback on this first item in terms of other kind of recent developments you think should be part of the this panel?
Yeah, there was a couple of things. I mean, we've got the recent developments in trust accounting. And do we put that in at all? Do we put it in with lessons from Girardi? Do we put that in with recent developments? So
yeah,
bring that up.
I thought about that too, Joel. I was actually thinking that might fall under the fourth one, the lessons from Girardi. But I agree with you that that's kind of a key recent development that would be helpful to address.
Yeah, because I don't think we could just cover that in a recent developments, because if you throw in, you know, the changes to the trust accounting rules and the presumptions and that kind of stuff that we've discussed, that might be worth a whole topic. And if lessons from Girardi is going to be the name of it, I'd volunteer for that. But I just wanted to make sure it gets its, you know, that's included in that concept.
Yeah. Okay, that makes sense. I think just so we're clear for the notes, and based on what I think Joel was saying, maybe we should copy and paste that to number 4. So going on to cryptocurrency, I'm not sure who recommended cryptocurrency. If you want to kind of discuss what you had in mind, I know there's a little summary on the screen now.
I don't know who recommended it, but I think it's a great topic to talk about. I don't think the opinion will be ready by then. It'll be close, but I don't think it'll be ready by then. But I think given the current state of what's been going on, I think it's a valuable topic to talk about, and the ethical implications involved with cryptocurrency.
I agree. Yeah. The next topic was social media. I feel like this is a very common topic for ethics discussions. At least I've been to many on this, so I'm not. But although when I looked at the kind of history of what COPRAC has spoken on at the most recent ethics symposiums, it looks like it hasn't been discussed much since the last one I saw was like in 2014, maybe. So maybe it isn't as common as I thought. I just feel like I see it a lot at bar association events as well. So that was my only concern, is if this would draw as much interest, if to me, it seems like a pretty popular CLE ethics kind of topic, but maybe we can give it a new angle.
The new ABA opinion, is it ABA opinion on the blogging would be a good kind of hook to talk about under that one.
Yeah. Sorry, I had to pull it up. So, that's the one, the reply all, right? ABA opinion 503. I think you're thinking of Cassidy, right?
No, okay. There was one on blogging recently. And it was basically, what can you talk about, and when you're, talking about a legal issue, and it basically has to do with the confidentiality issue. But the reply all one is a good one too, but that's not really social media.
I think it's 480. I think it's their formal opinion 480. If I could be mistaken, but I think that's the one on blogging.
It's recent, though, right? I don't know. I thought it was recent because I was just looking at something yesterday.
I want to say in the last 5 years. I think it was before the pandemic.
Oh.
Yeah, that's what I was thinking, that it was an older one. That's why I was getting confused, but I might not, I mean, not old, but like I didn't.
I must be, yeah, no, you might be right. I must be losing my mind. Anyway, okay, so let me double check that. I felt like there was a new opinion out on blogging, which is an antiquated term anyway, but so I'll look at that. I don't know.
I think it might have been 2018. I don't know. I'm trying to pull it up, but
A related topic, Sarah, and it's one that actually came up when we were talking about what the contents of a client file is, and it does have some, I'll say, relationship to social media, although it's more about messaging, is this idea of using apps and such for messaging and using texting with your client in terms of creating a client file. Some of the bar associations of other states have put out stuff on this, but we couldn't find anything that was really directly on point. It might be interesting to get into because I think everybody pretty much now texts with clients and stuff. So that might be worth looking into.
And when you say to create a client file, but you mean like whether that's considered part of the client file too?
Yeah, that came up. That was a thing that we kind of struggled with for a little while is, are the text messages part of the client file? And some of the public comments were like, hold on a second, I can't just turn over everything on my phone. It was a flash in the pan of an issue, but it was one that I think that might fit in somewhat adjacent to the social media issue, is those kinds of communications and communicating over social media, because I know that there are people who it's like maybe they don't have a phone that actually has service and they just communicate via Facebook Messenger or Instagram, Snapchat.
Yeah, there's a lot more ways to communicate through the apps, and like Snapchat and if you have clients who are in the tech industry, they communicate with their clients on all of those platforms, and it can be scary because there's nothing gets saved to a client file in any sort of traditional sense of that.
Yeah,
So
I'm
I don't
wondering if
know.
there's a way to kind of, I know this one's social media, but if we wanted to bring in kind of the recent client file issue that Hunter raised and bring in maybe even the recent ABA opinion 503, talking about communicating with your client via email and using reply all. I mean, when you copy your client on a message to opposing party, maybe there's a way to talk about I don't know, like electronic communications with clients and risks, associated risks. I'm not thinking of a. I just feel that if we're going to do social media, we kind of we should try to tailor it, because I am concerned that it's done a little too much. So if we can kind of come with a new angle.
There is, Sarah, this is Dan. There's one angle that we've been discussing lately is sort of like a throwback, but we see a lot of information on listserv circulation that looks like something you would not want publicly disseminated. And obviously listservs are sort of the original social media, but I do think lawyers don't think of it that way. And they started off as being sort of closed communities so that you're communicating with a particular community. But now there are various listservs that lawyers talk openly on that they have no idea who's receiving that information. And some of the hypotheticals are easily identifiable client scenarios. I wondered if that would be exactly.
I think that's a great idea, simply because to the extent our audience are people that are in the ethics community or have a large portion of people in the ethics community or April members and things like that, it's probably a worthy caution.
Yeah,
and it might catch everyone's interest.
It's not the only one, but it is one. But there are other ones that are even more tightly knit, like the Defense Counsel one and others. And I think people have a false sense of community on those listservs because they don't see them as social media. But if you tweeted that information, would that caution you, or, so that might be an interesting angle.
Yeah, Dan, as someone who was cross-examined a few years ago based on a post I had made a few years before that, when I was testifying as an expert, I agree. That's something we ought to highlight.
I will say, if we ever have experts being deposed, we do deep dives on listservs because that's where they're going to talk in an unguarded way.
I have to go back and look at all my listserv posts.
Yeah, you won't be sleeping tonight. You got to go back and review them.
Right. And then maybe, does anyone else want to weigh in on this third social media topic? I think maybe we should move on to the next one. Lessons from majority related matters, and which would involve also recent developments in trust accounting, as Joel suggested, which I think would be a good panel. What do others think?
Now, the only other part of that I can think of is that there were some changes in the disciplinary rules or the procedural rules, including a revamp of the special deputy rules. And there's a new special deputy administrator, which has been added to the program. And I don't know how many people, that's kind of esoteric, but that was one of the fallouts of the Girardi. And then there's the political fallout, but that's where we're going to have to be real careful if we do get there, that we watch ourselves in that area.
There's also some partnership related fallout. I feel like just this week there was the trustee is going after former firm members and spouses to sort of claw back payments that were received. And the theory, I think, that they were ill-gotten gains. that's definitely relevant for law firm partners to think about.
Yeah, that was surprising, but not, I mean, it wasn't surprising when somebody thought of it. It was just surprising that they actually did it. So.
Yeah. I mean, where else will you go? You have to go where the money is somehow.
Yeah.
The other thing that they're writing about is the inadequacy of the insurance policy. And you can question whether or not insurance would cover this, but apparently the insurance was very low. So that really took away a potential avenue of recovery.
Can I ask a question of maybe Randall or Erica on this? I'm wondering if by the time of our symposium in April, if the State Bar expects, you may not know the answer, but if the State Bar expects to have any data or feedback that it intends to provide to the public regarding the client trust account reporting requirements, how that's been going, lessons learned, things like that, that we might be able to draw from by the time of the symposium.
I can speak. So you're just to clarify, Justin, in regards to the CTAP reporting requirements?
Yeah.
So I don't think that's likely. And the reason is that, so the deadline for compliance technically is February 1st. However, as you can see in the public CTAP FAQ and in other documentation, the penalties for non-compliance have actually been extended as it relates to CTAP only, so that individuals can comply up to the beginning of April. So there may, because it's the first year that this program is taking place, so there is the possibility that the State Bar will have licensees who have not reported and registered as required by the CTAP rules until the beginning of April. So I just don't think the turnaround on any of that data would be available in time for the symposium.
Yeah, I mean, I guess let me ask a different question. I appreciate the sort of safe harbor period until April, but in light of the February 1st deadline, do you know if the State Bar expects to put out anything to the public related to these requirements in light of what it's seeing in terms of reporting questions? Maybe the frequently asked questions have not done it, and the bar is getting more nuanced questions than anticipated. And I'm wondering if there's any anticipated public facing documentation that we might be able to draw upon before our symposium, even if, say, statistical data is not available or something like that.
Sure.
Is there anything contemplated that we might be able to draw from?
Not that I'm aware of, but we can certainly go back to that program is being run by the Division of Regulation, so that's something we could certainly reach out to, and I could probably get an answer to you after the lunch break.
Yeah, that would be great. I mean, I just wonder, thinking out loud, how many lawyers are trying to understand the reporting requirements, looking at the frequently asked questions, and I have no idea how or to what degree that's generating further questions to the bar or internal conversation that might ultimately be public facing that we could draw from. I think that's
to the extent it's helpful, just so you're aware, the CTAP FAQ is a living document. So when the ethics hotline or the Division of Regulation or others are receiving questions that seem to be coming up a lot, or when the CTAP MCLE has been offered and we are receiving a lot of questions on a similar topic, we've been attempting to address those by updating the CTAP FAQ. So I don't know if that is sufficient, or if we could certainly provide like the takeaways and what has needed to be updated based on questions that have come in regards to reporting and registration requirements. But I don't know that there's anything in addition to other than the CTAP Living FAQ that exists currently.
And in that FAQ, does it show when you update it, so you can kind of track which are the newer questions coming in, or is it?
It shows. It doesn't show. I'd have to look at it just to give you an accurate answer. It doesn't. It shows the date that it has been updated, and I believe it shows the which questions were updated, but it's not drafted in like a track change type format to show the line revisions like we would do with like a draft opinion.
Okay, but you at least can identify the new questions, so those might be something that who's ever doing this panel would be of interest to highlight, like Justin was saying.
Can I ask a question about that? Oh, sorry, go ahead, Rand.
I was just going to say, I think Justin's instincts are really good in terms of COPRAC taking a look at the data that CTAP collects. And I think an excellent 2024 symposium topic could be client trust accounting by the numbers, where we have COPRAC do a deep dive and see what inferences and trending there might be and what the State Bar has collected. I think the audience for this symposium would be very interested in that, but it sounds like a program for next year.
I had a ancillary question on this issue, because when I did it, I was actually when I answered the questions for the compliance, when it says I think, and I'm paraphrasing, you've complied with the trust accounting rules. Is that, because I had someone had a question about this, is when you do this compliance, you make these statements, you answer these questions, is that for the previous year, or is that for all time, given that this is the first year that we're doing this? You know, you got 30-year attorneys who have trust accounts. Are they saying, yes, my trust account, I follow the trust account policies for the last 30 years, or is it just for the year in question? Does anyone know the answer to that?
I think the intent of that is to be a present tense statement.
Okay.
And so it's not intended for an attorney to be making admissions about any past client representations or trust account management or any sort of promises for the future. It's really saying, I've gone through the CTAP protocol, including the self-assessment, and maybe I've had an epiphany about how things should be done, and maybe I haven't been doing it quite right. But now I'm stating that as of today, I sent the memo to the management team and the in-house administrator saying the reconciliations have to be done monthly. We can't do it quarterly. It has to be monthly. And so when I sign my CTAP affirmation, I'm saying today, to the best of my knowledge, we're in compliance. And I think that's all it's supposed to represent.
Okay, that was kind of my initial thought as well. Thank you, Randy, for that.
I'll just add very quickly, Bill, that that question, if you need the written documentation to address it, it is answered by the CTAP FAQ current question 11, just so you know.
11, okay, thank you.
Mm-hmm.
Yeah, I just did my state bar registration yesterday, and one thing that surprised me is that nothing kind of jumped out and said, click here to go to CTAP or anything like that. And I was surprised. I was wondering why. We're not.
Are you saying when you access your My State Bar profile?
Yeah, I got to the profile I went to, and I finally found, click here to calculate and pay. And I did all that. And not once did it then say, before you're good, you got to go over here to CTAP kind of thing. And I thought I was sort of expecting to get that. And I got busy and I said, well, I'll do it another day. But I was just curious why that wasn't sort of an automatic boom.
I haven't looked at it through the lens of going through first and doing a payment, bar dues payment. I haven't looked at it through that angle in terms of going into the system. But I do believe when you first access your My State Bar profile, there is a prominent notice about CTAP compliance. But I'm not sure if your entry point is just dues, fees payment, if that's someplace where we might add something separately from the main My State Bar profile.
Yeah, I saw the notice box and said you got to do CTAP and all that, but
okay.
I had just assumed though that as I went through, then I clicked on calculate and pay, and I had just assumed that somewhere in that process, before it would accept my payment and say you're good to go, there would be something that would pop up and say, but you got to go over to CTAP first.
Yeah, I mean,
I was just passing it
see
along.
where it could be much more helpful to individual licensees to have a more integrated and unified process, but I do think some things still remain a little bit separate, and I think CTAP for now is set up that way, in the same way that your MCLE compliance would be separate reporting from dues paying. But I do think it's a good idea that in the future, some of these things try to be unified and integrated for the convenience of the licensee. It's a lot of programming that is involved in these things.
Is there any update on what the phase 3 of CTAP is? I know that it was something that was going to be informed by what they learned through the compliance period, but I was just wondering if there was any sort of more information on that at all.
I think that's still the current word on
nothing.
it. You, Erica? I think they're still.
No, yeah. And I think it kind of goes back to
Holding
Justin's
pattern.
question a bit, in that I think it's going to be informed by what is currently being collected as part of the initial reporting and registration requirements.
Okay.
Another subtopic for the 2024 symposium panel.
Right.
The one issue I just wanted to point out about this potential panel topic, Joel, you had referenced early on about something about procedural rules changes, and I do know that to the discipline process, and I know that from looking at some of like the suggestions that prior attendees have made at our ethics symposiums, it seems like some people want more information on the disciplinary process. So it might be a way to, if we can address that to a limited extent as part of this panel, might be a way to weave that in. But I want to move on to the other suggestions we have. Someone suggested the Eastman case that may not be appropriate until resolved.
And can you tell me just briefly what that's referring to? I'm just not familiar.
So I'm not the one who suggested this. I'm not, maybe the person who suggested it could weigh in. I think that's dealing with the attorney who represented, I thought, President Trump.
I'm sorry. I just didn't recognize the name here. I got it.
And so I'm not sure what the angle is that, what we would discuss on a panel here, what the person who suggested this topic had in mind, maybe. So I'll kind of pause, and if the person if anyone wants to weigh in on this particular topic, I'll open it up.
I'm not sure, I didn't propose it, but that dealt with the crime fraud exception to the attorney-client privilege, I believe, is the main thrust of that case. So, I mean, I don't know if that in and of itself would be the subject of an entire presentation. I guess it could be, but using that as the example case, and I guess other cases that have dealt with that issue, but it seems like a pretty narrow issue.
Yeah, I tend to agree. And I know we were talking, I feel like if we're going to do a panel perhaps on the Girardi case impact, I feel like that raises a number of additional issues and is, to me, might be of more broader interest to the audience.
I do think it would be interesting to do a panel in the future about Trump lawyers and where they've ended up and why, but might not be ready just yet. It's still ongoing.
Yeah, and that's what whoever suggested this mentioned, maybe it's not the appropriate time now to do this particular panel. So that's a good idea. We should keep this. I know we keep our lists for subsequent years so we can reconsider. So I think that's a great idea.
Yeah.
The next topic, I think we can kind of jump over to some extent, because I think number 6 really falls under number 1, the ethics update. So I think we should look at these particular suggestions here and to the extent we want to include them within the panel on recent developments. It would make sense to include it there, because we wouldn't want to have 2 panels on the same topic. So that would be my suggestion for this number 6.
Agreed.
And then we already went into social media, so I'm not going to go over that again. And I think, is this our last one? The telelaw. Oh, actually, we have a lot. Okay, so I think this is a great idea that the panel on telelaw, and I'll invite others to weigh in on this.
Oh, sorry, didn't mean to. What's the definition? Okay, so telelaw, does it include like legal Zoom and, you know, or the sort of basically non-law firm, or, you know, the alternative legal providers?
Yeah, and I was thinking it included AI too, issues.
Right.
Yeah.
Right. I mean, like, you know, the selling forms has always been fine, which is, you know, like the Nolo Press. But what happens when you are utilizing AI to customize so that it is essentially legal advice through that AI? So yeah, I think that's a good topic. But yeah.
And just so we can get through these, I kind of want to narrow down the list. So I want to just briefly go over the topics. So we only have two more. The confidentiality meets cybersecurity. I might be wrong. And I have to look. I should have double checked the list, but for some reason I thought, I know we issued last year, I think it was, or the year before, a COPRAC issued an ethics opinion, I thought, on cybersecurity. Not sure if that was already addressed then in a recent kind of recent development panel that we've done. So this one, for that reason, I'm not sure we should do it again. But I'll pause, because maybe there was, if someone who recommended this panel has some ideas that they wanted to raise for this panel.
I think the Covington case is interesting. It's something, I don't know if people have been following that, but the SEC is investigating Covington for a failure to disclose, and they're asserting privilege. I think this might be something that becomes more ripe for the next symposium, but there should be some interesting developments out of that.
Yeah, I agree, Eleanor. This next,
if you were wondering if it's been spoken about before, it was 2 years ago in the ethics update.
Okay, thanks, Mimi. Yeah, and for that reason too, I think that weighs in favor of kind of considering this for next year's panel. So it's not, since we did pretty recently discuss this issue, and by then we might have more of an update on the case Eleanor mentioned. This last topic, I'm not sure that we could angle it to ethics. It seems more of a general practice type panel, but maybe we could address. And my concern about this particular panel is I'd like to have panels that might be of wide interest. So this would kind of, if we did a panel on careers in tech law, it would be really focused on attorneys who might be interested in tech law. So I would prefer to do something that's from a broader perspective, to draw more attendees' interests. But
Sarah, let me just comment that out for public comment with regard to the minimum continuing legal education requirements is a proposal that there be a new required 1 hour credit in technology, including cybersecurity and privacy. And I think if that's something that is ultimately approved and adopted, then again, I think Eleanor's instincts, like Justin's, about a tech topic for the 2024 symposium would be very timely and appropriate.
Yeah, that's a great idea.
Flock to it to satisfy their 1 hour of tech competency credit.
Yeah, that's a good idea. So if you could scroll back up, so I think 9 and 10, I think we're kind of tabling for consideration, maybe at a next year's. It seems like 1 is something that we're planning to do. And Mimi, could you remind me, how many panels do we do again? Is it
You do
4?
a total of 4, and they're each an hour and 15 minutes each.
So we should try to figure out maybe our top 4 if we can now. And I'm not sure the best way to do that. I think what might be good is we typically have the members who are in their 3rd year, to the extent they'd like to serve as panelists.
Let me correct you on that, Sarah, also. It used to be 3rd year when you had 3-year terms, because now they are 4-year terms. It's technically your 4th year.
Okay. Yes. Okay. So if for members in their 4th year, and sometimes if they're interested in, would kind of get priority to lead a panel, and that would involve, arranging for the panelists for that topic, perhaps even if you'd like to moderate that particular panel. But so I welcome, and I should know this, I don't have the list in front of me, those who are in your 4th year, if you're interested in a particular topic. And Mimi, could you remind me of the members?
The 4th year members, well, Brandon is now going to be on your recent developments panel, correct? So that would leave Ken and Joel. It also would have been Kyla, but Kyla is no longer with us. And so therefore it would be Ken and Joel. They can volunteer to be a moderator for a panel. And if they choose to decline, then it would then go on to the 3rd years to see who would want to volunteer to do that.
And I heard Joel volunteer for the Girardi panel. Joel, is that still your preference? You're on mute.
Yeah, I'd do that, but I'm just curious. I thought this was my 3rd year, not my 4th year. But maybe I just lost a year somewhere.
No, this is your 4th year. You term off in 2024.
I told you it goes by fast.
Oh, wait, I'm very confused. Hold on. If it says expired, who turns
No,
off?
if I term off in 2024, that means this is my 3rd
You have
year.
one more. Yeah. Oh, it's Ken. Ken is terming off this year.
Yeah.
It would
I'll
have
still
been
be happy to volunteer for anything on that panel, but I just wanted to make sure nobody's kicking me off just yet.
I think what it was is you volunteered last year to co-chair the panel with Ken, correct?
Yeah.
So yeah, so actually Ken is our only senior member. Unfortunately, he's not here to volunteer for a panel.
And do you know from receiving the suggestions, Mimi or Angela or Erica, if he emailed any suggested panels in advance of this meeting?
He did not. These were suggestions from you, Sarah, Eleanor, and Raquel, who's also not here right now.
Okay. All right. So maybe we should agree kind of among ourselves what we think would be the top 5, and then we can follow up via email to try to narrow down.
And we've done that.
It sounds like we're going to need, aside from Ken, we're going to need 2 additional people to volunteer to be the panelists, and I guess we'd give priority based on years on CoPrac. Is that the problem?
Yes, and that would be Joel and Hunter.
Okay.
Would be next in line.
Sarah, to the extent that the social media would include, client communications through social media, which I think can be our angle to make it different, I would volunteer to moderate that panel.
Okay.
So we've done it in the past where we pick our topics, and then amongst the leadership and obviously the senior members, we would send out an email and ask for what their first choice and second choice panel is, and then we'd let the chair decide who should do what.
Yeah.
Yeah, just to add to that, I don't think it's going to be able to be like an all CoPrac email to finalize this.
Oh,
Which-
no,
Yeah,
it would-
I understand.
yeah, it would be limited to just the senior members, maybe fourth year, third years, which is 3 people, and then maybe Sarah.
Okay. So I think it'd be helpful to get some ideas of what, based on like the group who's here now, it seems like there's interest in the social media and the Girardi related matters. Cryptocurrency, I know it sounds like people were in favor of that. If you could scroll down, I forget what these other ones are now. The Eastman case, ethics update. So I think that,
It's the AI tele-law type.
yeah, so it seems like AI, tell law, and cryptocurrency would be the next, the other ones. In my mind, I think that based on our discussion, those are the top ones. Are we able to highlight maybe the ones just so we can keep a clear record of what we might consider? Okay. Because I think looking at the rest of the ones, they either overlap or they're ones that we talked about. It makes more sense to address them perhaps at the Ethics Symposium next year. So I think we have a good list right now. We have 5. The only other issue that I had in mind, because we don't have it on the list now, and I was trying to come up with a way to address it, but I thought it would be useful also to maybe do something on implicit bias. Since that is a CLE requirement, I think it's an important topic to address as well. And I thought there, in the leadership panel, I was debating if we do address civility, we can also address implicit bias as it relates to civility. But that also could be part of a separate panel, perhaps, or if others have ideas of a way to discuss implicit bias, we could also address. But I know I've seen panels on microaggressions that I thought were interesting. I know a great speaker on that, but what do others think?
Let me just chime in and say, in the past, when we've offered an implicit bias panel, we've gotten really good feedback from the attendees about it. They were really grateful to be able to attend a symposium that offers that kind of credit. And usually we put on some pretty good programs on it.
Yeah. So yeah, unfortunately, I haven't had a chance to really, I was trying to come up with a particular topic for the implicit bias and, have it. And I don't know if there's, I've seen panels on how to address microaggressions, and if we could tie that somehow to the rules or ethics, I think that would be useful as well. And I think with the new civility proposed rules and a lot of the findings of the civility task force, which I think are true, is that a lot of times in civil conduct is directed or motivated by bias. I think it would be useful. So,
Sarah, it occurs to me that the angle on implicit bias is where does the incivility come from? And one of the largest contributors to incivility is this implicit bias that people have against people who are different and that sort of thing. And they're not as civil to various different categories of our population as to others. So that might be a hook to the whole thing to make it into a program to break away from the recent developments and make it a cool topic.
I agree. And actually, now that you just brought back, because it's been a while, but since I've looked at it, but the Civility Task Force report has some great resources attached to it, including a couple articles on implicit bias and civility. And I think there are some great speakers as well, including judges who have talked about this. So I think we could probably get some good speakers to address this topic. So I think it's something we should consider, particularly since Mimi mentioned too that this has received good feedback from attendees in prior symposiums. All right, well, I want to allow.
Wait, I have a procedural question. Just the symposium is on the 21st of April, and it's going to be in person in Los Angeles.
We are at this time we are planning it to be a remote presentation currently. So that may develop, but for right now we're planning it so that it will be a Zoom presentation to the public and for the panelists.
Okay, because the physical wear of it might affect my ability to participate, but if it's going to be remote or in Los Angeles, I should be good. But if it's in San Francisco or somewhere else, I shouldn't. So please let me know as soon as that decision is made.
So I can tell you, Jill, just if it will help, it would either be remote or in Los Angeles. It would not be in San Francisco.
Okay, thanks.
Okay, so I think we have 6 topics to kind of mull over, and then we can discuss with the kind of working group of the leadership, and then with those who would be serving as potential panelists to try to narrow down everyone's top choice, who's going to serve as a panelist, and we can do that via email after this meeting. But before we move past the symposium topics, I just wanted to see if there's anything else that isn't on this list currently that people feel we should consider. Okay, well, since I'm not hearing anything, I think we have enough to go on for now. And I'd like to briefly address before we take a lunch break, the revisions to the draft ethics opinion that Cassidy took the lead on, which deal with in-house counsel. So Cassidy, do you want to lead that discussion?
Oh, sure. And I think it's going to be short because I just want to say that it's the opinion is now complete in terms of all the sections are filled in, but I still want to work on it further before we go through it. We did have a brief, email discussions with the subcommittee or subgroup. And one of the things that Brandon brought up that I want to go back and kind of massage is the 1.8.1 discussion, and just differentiating between when compliance with that rule is required and give more examples. I think Brandon, you were concerned with this being too bold of a statement, and just making sure that lawyers who are doing deals with clients know that they're going to, they really do need to comply with the rule. And I don't know if you guys saw, there's not a whole lot of case law on those other than the ones we cited in here, but there was a recent case in the Northern District, Schrader Gellers LLC versus Roach, which is a really good example of, a lawyer. There's a lot of different ethics issues in it, including UPL, because a Texas lawyer goes into business with a client friend and running a winery. And nothing was complied with, basically. So I want to dig into that and maybe use that case as an example. So it's getting there. I don't know if anybody has read through it, has any additional comments than in addition to what the subgroup has provided comments on. But I think a version should be ready by the next meeting to go over in more detail. So I'll leave it at that.
I just want to compliment you, Cassidy. I think this is a great opinion. It's really dense. There's a lot of issues that arise and are being addressed. So the fact that it's taking some time, I think just shows how interesting it's going to be.
Well, it's, this is my first stab at it, and I think I've said this before, but it's just, it's 2 steps forward, 1 step back, and then it's when I can find the time to actually, sit down with it, it's kind of some heavy lifting, and at least in my mind, as far as the analysis. So, sometimes that's kind of hard to get into when you've got, an actual job. But no, I think it's getting there, and I'm happy with it. I just, it's not ready to really be focused with a focused meeting on it. So thank you, Brandon.
All right. Well, I agree. It also looks great. And I looked at this because you were able to circulate it. So I think we'll just discuss this at our next meeting. And what I wanted to, I wanted to spend a lot of time on discussing the proposed rule 8.3, because I understand we're going to try to expedite our consideration of that. And I know it's 11:18 now, and we're scheduled to break for lunch at noon, but I'm just contemplating if we should, rather than divide up that discussion, if we should break for lunch a little early and come back earlier, so we kind of have a thorough discussion after the lunch break without interruption. But before we do that, Erica, do you have some updates that you can provide very briefly before the lunch break, maybe, and then we can come back with that in mind after the lunch break?
Sure, absolutely. So in regards to 8.3, I can kind of set the stage of what we're hoping to accomplish after lunch. That may inform how much coffee you need for this afternoon. So what we are hoping to accomplish is, as you're aware, and we discussed at the December meeting, the Board of Trustees at the end of November directed COPRAC to draft a proposed version of 8.3 for consideration by the Board of Trustees at the May meeting. That timeline has been even more expedited in light of State Senate Bill 42, which is a bill that is essentially proposing to codify portions of Model Rule 8.3. And so what we are hoping to achieve is the ability to present COPRAC's version of 8.3 to the Board of Trustees at the March 2023 meeting. It's in the middle of March, to expedite this process so that the legislature could see where the state bar is going in regards to a version of 8.3. So to accomplish that, what staff is hoping could be accomplished today is a bit different than what typically occurs with rules. And what that would look like is COPRAC's best version from today would essentially be something that is issued for a initial public comment period by COPRAC, because we're hoping to allow for the public to weigh in on a version of 8.3 as soon as possible, and to give as much opportunity for public comment as possible with these other considerations in mind. So assuming that the group can get to a version of 8.3 that they'd like to move forward, that would be something that is issued by this committee for a 30-day public comment period. Staff would prepare the memo to go with that, just like staff does with COPRAC opinions. And then it would be issued for a public comment period so that COPRAC has more opportunity to consider those comments and look to them for possible revisions at its March 3rd meeting. Related to that, because it's a short public comment period, staff is going to be setting up a public hearing to allow for members of the public who are unable to coalesce to give written public comments in time to present those orally, and then they would be transcribed for the working group and then the full committee to consider as well. And the way that this is somewhat different than the typical process is that typically rules of professional conduct are not, COPRAC's best version of that rule is typically provided to the Board of Trustees, who then takes that rule and then the Board of Trustees issues that rule for public comment. Any revisions based on the public comment are done at the Board of Trustees level. This one is a little bit unique in that we are hoping to get COPRAC's additional input on the rule after the first round of public comment is received. So we'd have the rule that's issued today, public comment on that rule, and then revisions to that rule at the March COPRAC meeting, and then it be voted on to be submitted to the Board of Trustees at that March 3rd meeting for, again, consideration by the Board of Trustees at their mid-March meeting.
Okay. Well, thanks, Erica, for that update. And so I think with what you've reported, and I know the working groups also met, we should come back kind of ready to discuss what was circulated as part of the agenda materials, which is a draft proposed rule 8.3, how we might want to tweak that, which is not, it's narrower than the ABA model rule 8.3. But I think if, before we come back, if you could try to take some time to look at that proposed rule 8.3 that was circulated as part of the agenda materials, so we can just focus our discussion on that. All right, well, thanks everyone. And let's see, it's 11:23. How about we say we return, it's kind of an odd time, so how about we return at 12:25 to resume discussion.
Yeah, one last question. The March meeting, that's the one that's in person in San Francisco?
I'm going to confuse things even more, Joel. That one's actually going to be held remote as well. So the next meeting, the March 3rd meeting, will be also a remote meeting, and we'll recirculate the calendar, but it will be a remote meeting conducted over Zoom for the March meeting.
Okay, great. Thanks.
Okay. Bye, everyone. Okay. All right. Hope everyone had a good lunch break. I was multitasking, but I wanted to start a discussion of proposed rule 8.3 and the version that's on the screen now that was part of the agenda materials. My understanding is that this proposed rule was developed through State Bar staff. And as Erica mentioned, kind of right before the lunch break, as background, there is now pending Senate Bill 42, which would propose to adopt essentially ABA, a version of ABA model rule 8.3, which is much broader. And this rule is narrower and kind of similar to, I think, what Illinois has adopted as part of its rules of professional conduct from looking at it. But I think I wanted to, I understand that at our last meeting, where we kind of just discussed very briefly our charge to evaluate a new rule of professional conduct similar to ABA model rule 8.3, that there was some opposition from COPRAC members to doing so. But I think our task now, particularly in light of the proposed legislation with a version of rule 8.3, is to really prepare COPRAC's best recommendation if there were to be a rule requiring reporting of professional misconduct based on our expertise, what we recommend as kind of the best version of this rule. So I think that's what we should focus on during this meeting, is really tweaking the language of this draft rule. I know the working group has met to discuss proposed rule 8.3, so I want to let them lead the initial discussion of this. And perhaps I could, Brandon, if you want to start leading that particular discussion, I welcome it.
Sure, I'm not certain I'm the best one to lead the discussion because
Okay.
there were a lot of inputs, but so we got language tweaked back from State Bar staff that we discussed at length. And there are a couple open issues that we're still discussing. This is the product of our meeting this week. What's before you. Joel had some really interesting concerns about a safe harbor provision for people who make good faith reporting and whether that should be in the rule versus maybe a comment. And we did have some discussion about the requirement in number 1 that it be a criminal act, whether that sets the bar higher than, it certainly sets it higher than the proposed Senate bill language. But I guess I don't have much more to add. Maybe Erica does. I just think after the time we spent on it, this was sort of the most agreeable form we could get it in to propose to the meeting.
I have a couple of questions, Brandon. The first has to do with the term personal knowledge. Is
Yep.
this going to be personal knowledge essentially the way it would be defined under the evidence code? Or would it include essentially hearsay statements, or am I just going down the wrong analysis altogether?
That's not a wrong analysis. We talked about that a bit because I believe the prior draft had knowledge with the asterisk as a defined term in the rules of professional conduct. And we wanted to change it to personal knowledge so that it had to be a bit more solid so that it wasn't just inferences being drawn or hunches. But I don't have a precise answer to your question about how this would square up with the evidence code.
If I can jump in, Brandon, I was looking because one of the questions I had before I left yesterday in our meeting was, judges have the discretion to report a lawyer if they see misconduct. And I think Erica asked me to look at or look at the canon of judicial ethics to see what the judges, is it mandatory or is it discretionary for a judge to report, say another judge, if they see misconduct, and that's set forth in canon of judicial ethics, canon 3D, which is entitled disciplinary responsibilities. And what that says, and I guess it'll get back to your question about personal knowledge in a second. Under sub 1, it's dealing with other judges. And it says whenever the judge has reliable information that another judge has violated a provision of the Code of Judicial Ethics, that judge shall take appropriate corrective action, which may include reporting a violation to the appropriate authority. Appropriate authority defined as the authority responsible for initiating disciplinary proceedings. So that's as it relates to other judges. Now, as to lawyers, it says whenever a judge has personal knowledge or concludes in a judicial decision that a lawyer has committed misconduct or has violated any provision of the rules of professional conduct, that judge shall take appropriate corrective action, which may include reporting a violation to the appropriate authority. So the corrective action, is more along the lines of, it says in the comments, direct communication with the judge or the lawyer who has committed the violation, writing about the misconduct in a judicial decision or other direct action. It says such as a confidential referral to an assistance program, or report the violation to a presiding judge, appropriate authority or other agency. And then under the judicial canons of ethics, they do define personal knowledge. There is a definition of personal knowledge that I think it was very similar to what we were talking about yesterday. Let me see if I can pull it up here real quick. Give me 1 second. I just had it here. Shoot. Oh, it says knowledge. It says knowingly knowledge known or knows means actual knowledge of the fact in question. A person's knowledge may be inferred from circumstances. That's how the canon of judicial ethics define knowledge. That helps.
And that's the same definition under the rules of professional conduct as well.
I believe so, yeah.
Yeah.
But I don't like inferred from the circumstances.
I don't like that either.
I think we need to have a higher standard. And I mean, I don't know what other consequences there would be or whatever for having personal knowledge, have it be the same definition as in the evidence code, but that's kind of what my intent would be, which is, you know, the same type of standard you would need for a declaration. Because you know, again, you don't want it to be based on hearsay.
Right.
I tend to agree that narrowing that definition as narrowly as we can is a good idea. It's one thing to say a judge can report another judge or a judge can report an attorney. Attorneys, we're in an adversarial context. So the idea that we can weaponize this against each other is a little bit more scary. And so I think that power has to be reined in this rule, and the comments do a few things for that. That's my first concern. My second is in 8.3 sub C, that seems to be a good idea, but it got me thinking about California Health and Safety Code section 11376.5, which was essentially a safe harbor provision from criminal prosecution for people who are reporting overdoses. So hypothetically, a bunch of lawyers get together and they're doing a bunch of cocaine. One of them falls down and their heart stops. They're not in a drug treatment program, but how many of them want to be disbarred if they call the police and try to get emergency personnel over there? Right. And so the question is, and obviously, I'm not hoping that we'd ever run into that specific hypothetical situation, but the question arises is, are we going to consider the possibility that anytime you're reporting an emergency to save a life, would there be a safe harbor for that? And that's one of the things that occurred to me, because I don't think comment 4 would be sufficient to clarify C to include that kind of concern. Because if we have lawyers in drug treatment programs, and the chances that we have lawyers who find themselves in this circumstance, while rare, is completely foreseeable. I mean, we might want to do that. Have you guys given thought to that potential issue?
Hunter, if I could expand a little bit, I had two concerns coming out of our meeting with the subgroup, and I'm not sure I'm satisfied with where we are. The first is that one of the statutory schemes that I've had some experience with in the past is mandatory reporting of teachers and healthcare providers where they suspect or find evidence of child abuse, that there is an absolute immunity built into that statutory structure, so that if a report is made and it turns out to have been unsupported, or it turns out to be incorrect in some way, the reporter who has made this mandatory, is required to make the report, has a safe harbor of immunity. The second concern I had is, again, from personal experience, where as an expert in ethics, from time to time, I get a call from a litigator who wants to know how do I make a state bar complaint against an opposing counsel and that sort of thing, and what do we do about the timing of it, and what is its effect strategically in the ongoing litigation out of which the conduct was observed, etc. And then you wonder, okay, now as an expert, I come across all the evidence of the suspected attorney's misconduct. Now, do I infer from those circumstances that I have an obligation now to report, even though I was consulted by somebody who wanted to know if they had to report? So, and And I was referred to subsection A, where it talks about personal knowledge, but if that includes from the circumstance or surrounding circumstances, then maybe I don't have a safe harbor. Maybe I have a requirement to report, which would kind of be counterproductive to the whole concept of an attorney knowing that they can contact another attorney who might be an expert to get an opinion on what their obligations are. So those were my two concerns, and other than lay them out on the table, I didn't have time to continue participating in the meeting, but I thought I'd bring them up right now because that's really the concern here that I have with the whole thing. If we're going to require, as seems to be inevitable, that we've got to rat out our colleagues, there ought to be some safeguards and protections that allow our colleagues to seek advice and that allow anybody who makes a report that turns out to be fails in prosecution to be some kind of immunity. So those are my concerns.
Along those lines, Joel, I had the same concerns on especially with your second point. I was actually, after our meeting yesterday, I was in a meeting, the California Lawyers Association, a subcommittee for ADR, the ADR subcommittee, and they brought up SB 42 and their concerns about that issue. In particular, what if you're in a mediation and one of the lawyers commits misconduct in front of you as the mediator? Do you have to report that? I mean, how does that square with the mediation confidentiality provisions? And so there was a lot of, when they brought that up, I mean, unanimously, everyone does not like this rule and does not want this rule and doesn't like SB 42 for that reason. So, I mean, I can see under C or by other rules or laws that you can argue, yes, other law would be the mediation confidentiality or the health and safety provision that Hunter mentioned. But that leaves it open to interpretation. And I think if we're going to have a rule like this, I think it needs to be extremely narrow. And along your line, on the flip side, you're concerned, Joel, about having a safe harbor. In my mind, because I agree with Hunter, this thing can be weaponized in litigation. There ought to be, or we ought to think about having another subsection where it says if a complaint is frivolous or made in bad faith, that person reporting that doesn't get to rely on the safe harbor and can be subject to discipline, him or herself. I mean,
and we run up against the problem that Joel's pointing out, which is if you're going to say they shall, right? The question becomes, is this malicious or are they wrong?
Right.
Which leads to my next question, which is what, if any, overlap or lack of overlap exists in essentially comment 5, the 6043.5 of the Business and Professions Code, and 8.3A2. So let's say somebody makes a report under this, and the person they reported thinks that was done with reckless indifference, not necessarily malice, but reckless indifference to the facts, and says, well, I'm now going to report you under 8.3A2 because even though you didn't fall afoul of 6043.5, I think in the reckless indifference of reporting this to administrative agency, you fall under, you're making a violation of this yourself. Again, the weaponization seems to be my greatest concern about it, but that's a question. And then another question is with regard to 8.3B, I noticed that there's this idea of balancing potential prejudice to the client against the lawyer's duty to report. My mind goes to the evidence code, section 352, right? The balance of prejudice versus probative value in evidence. But the question of that is always, what is the burden? What is the standard, right? And the standard of review. So if somebody does this analysis and the state bar disagrees with their conclusions, how much deference is the attorney going to be given in their in what they do when they've done this balancing. Since there's no neutral third party like a judge who gets to be subject to an abuse of discretion standard upon review, what standard would an attorney who makes this balancing test and comes to a conclusion that maybe the state bar disagrees with, what standard of deference would they be given, if any?
I think that's a good point, but I think that keep in mind that B really has to do with the timing of the reporting and not whether or not they should report at all.
Right. So let's say they wait a month and the state
Yeah.
bar says that's way too long. You should have given it a week. This is way too long. What's the standard of, I mean, if you're off by a week, if we think there's an abuse of discretion, which doesn't really make sense in this context.
Yeah, I think, you know, the debate we had over that part or over that provision was, well, should it be in there at all or should it be in a comment? Because there's no timing requirement in the rule itself. It's just a shall. It's not shall promptly, you know, report.
Which means it can all go on a deathbed confession.
Right. I mean, right. So, but shall means, you know, shall means there is kind of a timing component to it because you have to do it, you know, and it doesn't make sense if you did it on your deathbed, right? So, yeah, I mean, I think that, and this language was taken from an ethics opinion in Colorado that addressed the timing, and under the Colorado rule, there's no timing component in the rule, and so they, you know, that's why the ethics opinion was issued to address, well, when should you? And so that's where the rule came from. But I would suggest, well, and I think that the message there is that it's up to the lawyer's professional judgment. So it should be in the discretion of the lawyer and not, you know, but then where do you go? Like who, I mean, there is an ultimate authority there. And of course the state bar is going to say, well, sorry, that was an abuse of discretion, you know. What's the discretionary standard? So those are my comments on that. I don't have a preference, I guess, one way or the other, whether it should be in there, whether it should be in a comment or not in there at all. But I thought it was important to raise.
Cassidy, for the reasons you just explained, I would favor having that as part of a comment. That was when I looked at this proposed rule overall, I thought B was kind of more difficult to understand and apply, you know, how it would be applied as a practical matter, as Hunter was saying. I was concerned about that, and I felt like perhaps more guidance was needed too. So if I was contemplating it, should we have a comment addressing B, but I also think because the rule doesn't have a time frame currently, it would be better to include subsection B as part of a comment and maybe provide a little bit more of an explanation of what we mean or an example.
Yeah, because the timing of it will raise, it will cause confusion because it's going to be the situation where you're in the middle of a case and there's, you know, a violation by opposing counsel, and the question is, you know, all these issues pop up. Well, is this going to harm the client? And wait, you know, so there's competing interests there. So I agree that a comment to provide guidance on that confusion is appropriate. You know, or the alternative is do what Colorado did and issue a full-blown ethics opinion on the rule, which will probably be necessary at some point. But
in that vein, with regard to weaponizing during litigation, I think a comment to the effect that during active litigation, if that's when this comes up, you against your adversary, then really the authority that you should be going to is the whoever's presiding over the case, whether you're assigned to a courtroom or a judicial officer. I think that would take care, at least, you know, trial issues, right? You're in a trial and somebody decides to report you to the state bar during the trial. That can cause all kinds of headaches. But if we direct them to say, like, look, if you think, for instance, that there's been a violation during this trial, the person you should be taking it to is the trial judge.
Well, yeah. And the other thing too is you can't threaten this, right? Because then you're gaining leverage in the action. So
Right.
a reference to that rule, right? It's in a rule.
3.10.
Yeah, I think that's important too.
And that's referenced in the comments, but it's one
Oh, it
thing
is?
to
Oh,
threaten
okay.
it, but it's another to just go do it. You know, you could be racking up, 3 or 4 complaints a day while you're in trial and not know it. And that uncertainty is going to cause a chilling effect on your zealous advocacy, potentially.
Yeah,
That's really what the concern is if you think somebody's violating this rule, then who you should take it to during a trial would be the judicial officer if it's in relation to that litigation. I don't know that that would fix anything, but on the fly, that's my thought, is the best way to avoid the chilling effect or the weaponization of it.
So if I may, the discussion that you guys are having right now, which I think is really important, raises another issue for me, which I just have no visibility into how this rule is intended to accomplish goals, right? Because I had not viewed it in the adversarial context where it's just like begging for abuse, right? But I had thought of this more in the context of people in a law firm. I thought it was all out of the Girardi incident where I'm in the law firm. I don't really touch the money, but I have some knowledge. I've overheard some stuff that this isn't right, and I'd better report and put an end to it. I personally think those lawyers, the people that would have knowledge of that sort of thing, already have fiduciary duties to the clients. They're already duty bound to try to set this right. I am really unclear on, in other states, does this
happen.
do anything to protect the public?
Well, Brandon, I took a look at what Cassidy sent us, which is the Colorado. And by the way, those were comments to their rule, not an ethics opinion.
Oh,
Which is better than comments are better than an opinion. But they do add some things when you get into topics like from the surrounding circumstances and exercise judgment as to timing regarding prejudice to the client, et cetera, and whether your client says yes or no, all those kinds of things. Since they do fall into judgment, that's where I come down to there ought to be a safe harbor of saying, okay, if you exercise all that judgment and you turn out to be wrong, as long as it's not frivolous or malicious, you ought to be protected. So you don't have to later come back and say to somebody, I exercise my judgment, and your judgment comes into question, and maybe it's judgment over which other people with different strategy, ideas, et cetera, could differ. And if that becomes the basis of a future discipline action against someone who's only trying to do what they're trying to do or instructed to do, shall clean up the profession, they ought to have some protection.
yeah, but can't the safe harbor also be weaponized when you're talking in the adversarial, setting where you're basically saying, well, as long as this isn't completely frivolous, I'm gonna, or it's shown to be completely frivolous, then I'm gonna report this opposing counsel for, something fairly minor, and is, actually being used as to gain leverage in the proceeding. It's used improperly, but the safe harbor would provide some protection for that lawyer, or some comfort that they have some protection. In other words, it gives more freedom for the reporting, and we want to rein it in more than anything.
I've said this before, and I'm just so deeply conflicted or troubled or whatever we say, is that I have no problem with a carefully crafted duty to report rule 8.3. I don't actually have any sort of reflexive animosity towards it. My biggest concern is that this all seems to be in response to a problem that it can never solve and will have no impact on and it seems to be moving really quickly so that we can show that we're doing something. And I'm not really interested in acting as if I think this addresses the crisis that it's responding to.
Yeah.
I'm concerned.
I would like to know, I would like to have some kind of survey, and I think there was a discussion on the April listserv not too long ago about, you know, what really the other states use this for, and you know, is it typically about theft, you know, theft from trust accounts, and it doesn't make a meaningful difference. I mean,
how
I'm
do we
sure
get that information? I mean, isn't the disciplinary system like pretty darn confidential? Like, I don't even know enough. I don't do the discipline work, but can we get that information?
Yeah,
Well,
I mean, Joel, does anybody recall that exchange on the listserv?
Yeah. The discussion on the APRL listserv was about, well, what have other states done? What do we know in other states? And the only
It's New
specific
Jersey.
that was cited was a case in Kentucky.
Oh, yeah.
Where an attorney actually went to the press and articulated a complaint against some other attorney about bad conduct. And the attorney general then brought a claim against the lawyer who made this statement in the press. And the speculation there was that the only reason that it had gotten that far was that the district attorney was pissed off that the lawyer went to the press instead of coming to the district attorney first. So, but that was the only one incident in the other 49 states of the people who participate on the APRL listserv can cite, where there was actually some complaint brought against a lawyer for failing to report under their version of 8.3.
Yeah, I also recall discussion from one of the Illinois attorneys about Illinois' rule, which is somewhat similar to this proposed rule, and they felt that it wasn't weaponized. You know, there are concerns about that, but in reality, it hasn't been. At least that was the opinion of the one attorney on the listserv as to Illinois' rule. But
Yeah, I don't think there's a lot of, I mean, the cases yeah, I mean, the cases that I've seen on the, you know, where they have reported, it does typically have to do with the, you know, misappropriation of trust funds. Because I think those are the ones that are pursued. But I guess, you know, I guess what I'd like to know is, out of all the duty to report matters, which ones are actually pursued and what types of cases, you know what I mean? Like, they could just be reported and because it was a mandatory reporting, and then they get shut down quickly, right? Or so.
Also, further to Brandon's point, as someone who, in my role as a special deputy, and I'm not allowed to name names, but I was involved in a couple of investigations regarding an attorney who's been in the press recently. And the responses really didn't indicate a trust violation. You know, the response was, well, there was timing issues and this, that, and the other, why a client didn't get a settlement fund. And without a full-blown investigation and audit of that particular attorney's trust account, how was even an investigator supposed to know that the violation was not just failure to be responsive to a client, but actually the basis of it was a misappropriation of trust funds, and there was no money to distribute to the client. So I don't know how a third lawyer somewhere out there is going to know what the other lawyer is doing, that it does involve a trust account specific.
Right. Yeah, you'd have to be part of the same firm. And like what Brandon is saying is that they already have fiduciary duties, you know, that protects against that. So get back to the original question is, what is the purpose here? What are they trying to solve?
Yeah, but then we get we still get back to the point of this train is barreling down the tracks. And so the best we can do is find enough lipstick to put on the pig from our perspective and see if they'll do it. And maybe it'll be a rule that will just be there and it will say, okay, California's just like everybody else. And yes, we take this seriously. And if in the next 30 years, there's 1 or 2 times when it'll come up, so be it. But I think our job would be to concentrate on what language, whether it's in the actual rule, which I would prefer, or in comments, that would address these issues and give some comfort to those who might take this duty shall seriously and find themselves in trouble for having done that, or who look at it seriously and conclude they're not going to do it because of the totality of the circumstances or the exercise of judgment, and then they should be protected for not doing it if they do that in good faith.
Yeah, I agree with you, Joel, that we should try to focus on putting our best language that we can during this meeting to revise the rule. But as to the safe harbor provision, which we should discuss more, I also have similar concerns to what Cassidy raised, I guess, about that in terms of, whether a safe harbor provision could be abused because it would perhaps encourage bad faith reporting, even though we try to carefully craft a safe harbor to make sure that, it only protect good faith reporting under the rule. But I share Cassie's concern that would provide comfort to someone who is going to report something that really didn't warrant reporting just to gain some sort of advantage. So I am concerned about a safe harbor provision. I'm also curious, and I don't know if this is something the working group or State Bar staff knows, do any other states have a safe harbor provision?
I can briefly address this just based on the ABA model rule comparison chart. I haven't delved into every rule myself, but it does not appear that there is, at least in the rule itself. So the model rule comparison chart addresses the language of the rule, not the comments, but it does not appear that does exist. When staff presented the initial draft of this, we did attempt to address the safe harbor concerns as well as the false malicious complaint concerns in a comment. So those already independent statutory obligations in respect to both of those issues. And so comment 6 attempts to address those things. I don't know if Angie, you want to scroll down so everyone can see them. Certainly that could be moved into the rule language itself, but it was attempted to be addressed in some capacity through references to those authorities.
And wouldn't there already be some kind of immunity with respect to like litigation privilege and that sort of thing? I mean, you are protected just by virtue of filing the report in an administrative proceeding or official proceeding, right? So they can't sue you for defamation arising from the report. Beyond that, I don't know what other, unless they were reporting you to the, who you report. What I think what Joel was saying was if you report maliciously and then you get reported because of your malicious reporting.
So in the comment that Erica pointed out, we refer to 6090.5 with respect to the privilege and immunities for communicating with the state bar regarding lawyer misconduct. And I think you raise a good point that maybe that's not the only citation that should be included. We could include the Civil Code, Section 47, because there is at least one Court of Appeal case, Chen v. Fleming, which finds that there is an absolute privilege with regard to complaint to the state bar that one attorney could not sue another attorney for alleged libel. The Court of Appeal case in the summary says, thus, in an action by one attorney against another attorney alleging libel and other causes of action, which arose after defendant attorney wrote a letter of complaint to the state bar regarding a fee dispute, the trial court properly sustained a general demur to the complaint and ordered the cause dismissed, citing section 47 of the Civil Code. So I think if we want to buttress what we already have in the specific State Bar Act immunity and privilege section 6090.5, you could add section 62 and 47. You might even add a cite to the Chen v. Fleming case if you want to.
Yeah, but right. And so the only, and I think that that's good. But you could be, so malicious prosecution would still be on the table, I would think.
Right.
Or what, that wouldn't, you're not.
Well, I guess if it went all the way through an adjudicative proceeding, then I think you
right.
have a
But
malicious
then you're not
prosecution
even,
case.
yeah. I mean, you don't have a malicious prosecution case because you're not the plaintiff, the
Right.
reporting person isn't the, so that wouldn't work. Or maybe abusive process, but that's subject to
That's
litigation
subject.
privilege. Yeah.
Yeah.
Well, if these safe harbor type things exist, then certainly I would agree that section or comment 6 ought to be expanded to lay those out more specifically than just a citation to a section number, and kind of give those attorneys who would take on this duty reluctantly, at least to know where the boundaries are pretty thoroughly and specifically.
You could pull language right out of 6090.5 and put it into the comment. I don't know if we can link to 6090.5 because the wording is pretty straightforward, I think, used in the statute in terms of, I think it's something along the lines of no action may be predicated thereon. But
6090.5.
I think, do you mean 6094, Randy?
6094, yes, sorry. I'm using my laptop with the tiny.
Yeah, and I do think
6094.
And I was just looking at that, and I agree that it's pretty clear, and I think that addresses the safe harbor.
So if you quote it, then that's would have the messaging effect, I think, that some folks are seeking.
Yeah.
Although I thought the summary, with respect to privileges and immunities regarding communications relating to lawyer misconduct, the rule itself, I don't know, I'm looking at I just pulled up a version on Google, communications to the disciplinary agency relating to lawyer misconduct or disability or competence, or any communication related to investigation or proceeding and testimony. It could be kind of cumbersome to quote the whole rule. But it says our privilege and no lawsuit predicated thereon may be instituted against any person. So
yeah, well, that would take some of the or add clarity to the language of the rule itself about as provided in other laws. If the comment were to very specifically lay those out, and maybe with the case site, that might be enough to do it. I'd have to take a look once we get it all put together, but that's a step forward. As well as the, I didn't compare the Colorado comments that Cassidy sent with these proposed comments. They seem to be a lot more, in Colorado, a lot more detailed than our comments as proposed. So I think we ought to do something to see what we can co-opt from what Colorado has done too, and perhaps any other jurisdiction. What's 609 on 20? Oh, okay. 604.
I think, since we're trying to make the edits on the spot, and I just pulled up Colorado's rule, which I'm not seeing a lot of detail in their comments or anything about a safe harbor, but I might be missing it. But if we want to be clearer with the 6094 privilege and immunity, maybe it would be helpful, Angela, if you could pull that up on your screen so we can determine what part of it we might want to. It sounds like if people are in favor of quoting that to be clearer. I think that would be useful to try to work on some redlining on the spot. Because I think this is
It might be cumbersome to quote. You could just use a classic bracket or parenthetical establishing immunity in prohibiting any action. We can summarize whatever the most resonant words to put into the comment to have it convey the appropriate emphasis. I think you can.
Yeah, and I just think to be clear, the privileges, what right now we're referring to privileges and immunities, and that might not be clear to everyone. So I think the language "no lawsuit predicated thereon may be instituted against any person." That's kind of from looking at the rule itself, I think that's the clearest language. So no lawsuit may be based on a communication to the state bar relating to lawyer misconduct.
Do we have any authority to say that? Well, no, never mind. I was going to say, can a rule of professional conduct prohibit a lawsuit under substantive law? But I guess it is part of the State Bar Act. So.
What was that, Brandon? I missed it.
I was just thinking out loud that can we just in a rule of professional conduct prohibit a lawsuit arising from a frivolous filing or whatever? But I suppose we could because it's part of the State Bar Act, right? Does anyone know?
Yeah, it's not part of the State Bar Act. It's approved by the Supreme Court. The State Bar Act is approved by the legislature. And so it's a statute. So it goes through the legislative process and is, authored.
Right.
So they're independent paths. There's some crossover in a lot of areas, but.
Yeah, and my recollection, Brandon, is in other areas, a rule promulgated pursuant to a statute does not trump another statute.
Right.
So that's just a vague recollection, but it's something we'd have to track down.
I did briefly just look up Colorado and looking at, again, the ABA comparison chart and then Googling the Colorado rule. It appears the Colorado rule itself is almost identical to the ABA model rule. So I don't know if it's hard to, Joel, I'm not sure I think it might have been an ethics opinion, although I'm having trouble locating the opinion itself.
Well, no, these are the comments.
Because I should have that too.
Oh, maybe they're the comments in model rule. Oh, maybe it was I misunderstood here.
It appears the comments to Colorado rule are very similar, at least to the model rule comments, but
okay,
I may be looking at an old version or something as well.
What's it's opinion 64, right? Is the opinion.
It's also from 1996.
Yeah. So it is at the, yeah, it's from 96. It's the, yeah. Oh, but do you think that let me see. Maybe they updated their rule to include the opinion into the comments.
Has anybody read the article that Colorado cites, attorney's duty to report, a roadmap to reform? What is it? 16 George J. Legal Ethics?
Yeah, the Georgetown.
Oh, Georgetown. Okay.
I think that's what it is. I might have looked at it last year when I wrote that memo. And if you look at the end, just going back to the immunity conversation, there is a discussion in there, I think, about immunities that I briefly cited at the end of my memo in there. So, but beyond that, I don't, let me see if I might have it saved. But that would be a good resource, is that article. Isn't it a Peter Jarvis, didn't it? There's somebody who, I think Peter Jarvis contributed or wrote something too. I think I think, Joel, what you were maybe confusing the comment 3 for Colorado, under Colorado's rule that we talked about during our subgroup meeting, was having to do with interpreting the word substantial and offering a measure of judgment for the lawyer as to whether or not the offense is substantial enough to report, which is not in our language. And then the timing issue that is covered in the ethics opinion. So there's still, the judgment call as to when to report, I think, is covered in the ethics opinion versus the judgment call as to whether to report at all a substantial, whatever the word is, substantial question is in the comment. And we decided not to put it in the comment because we don't have substantial question. It wouldn't make sense.
Well, maybe we should.
Well, I know. I mean, I keep going back to something that instructs or gives guidance as to how to identify a violation. Whether or not it's a violation, whether or not it's a clear. And I think we address that by saying personal knowledge. You have to have a direct evidence of the commission of a crime involving what A and B. So I don't know. I mean, I would be in favor of more comments that provide guidance and that it's geared towards narrowing the rule as much as we can get away with.
Yeah.
I'm just in order to try to move forward, I'm thinking maybe we've talked about many different issues that we want to address, and I want to try to maybe focus one at a time and try to resolve those with red light language now that we've kind of opened it up for kind of an overview. Just because I think if we're going to need to vote on this rule at this meeting, I think we should try to start on working in some of the revisions to address the issues that everyone has raised so far. And I think maybe the best way to efficiently do that might be to start from the beginning and the first issue raised and address things one at a time. And my understanding, the first issue raised, from what I heard, is the term personal knowledge, what we mean by that. And it seems like, based on what I've heard, that, and I wasn't on the working group, my understanding is that the working group wanted something stricter than what's in the current definition of knowledge under the Rule 1.0F, which is defined as actual knowledge, which may be inferred under the circumstances. So we didn't want the, it sounds like the working group didn't like the language inferred under the circumstances. But if we're going to use personal knowledge, I think we need to somehow define what we mean and how that's different than the definition of knowledge under the rules would be my recommendation. I don't know if we do that in the rule itself or in a comment. But I think we need to, I would recommend we define that term somehow.
I agree. And I think it should be two things. One, define it and make sure it's not the same definition as the general definition of knowledge. You know what I mean? So we would have to.
The definition that I would suggest is something along the lines of present recollection from an impression derived from their own senses, right? And that's the type of definition you have from the cases in the evidence code, but that allows us to distinguish it from basing this on hearsay statements.
Can we cite directly to the evidence code, or is that more problematic?
You can, but as far as I know, the evidence code basically just says personal knowledge.
Yeah, that's what I thought. That's what I was gonna ask. I didn't think there was.
That's 702. I don't know that the code really defines it. It's more of a requirement of competency under the California rules. But it really comes down to, right, current capacity to recollect, which is more an issue of being a witness, but based on their own perceptions.
Well, yeah, well, then I'm in favor of that definite, what you've said initially, Hunter. I'm actually defining what personal knowledge is.
Hunter, can you repeat that?
Sure, I actually pulled it from this Alvarez case, which is present recollection of an impression derived from the exercise of the witness's own senses. That might be better stated with some clearer language, but that's what it comes down to.
I have a hard time with that kind of language because that's talking about the witness's competency to testify and be a witness on a matter. And what we're talking about here to me is somewhat different. It's hard to apply that particular definition to this rule. Maybe some parts of it we can incorporate.
To the extent that it's about present recollection, yeah, that doesn't really apply here. That's not what we're talking about. But in terms of their knowledge is based on their own personal observations through their own senses.
That's right.
Is what I'm suggesting.
Gotcha.
Like you saw it with your own eyeballs.
Heard it with your own ears, smelled it with your own nose.
Yeah, that's what I would want to get to. Yeah.
Yeah, so maybe, so first, do we think we should develop this definition in a comment, like maybe the first comment to this rule?
Yep.
Yes, okay. and we'd have to explain that it's distinct from the knowledge definition of the professional rules themselves.
Yeah, right. So do you want to start drafting that maybe now? Maybe we could just put a new comment 1 and then just say personal knowledge under subsection A.
Should we put it in quotes, like personal, like,
yeah,
it's a phrase that goes together.
Just so the group's aware, in several other, it's used in both comments and in the text of the rules. It's oftentimes used as, you know, the final paragraph of a rule itself to say, as used in this rule, the term, and then that term is quoted, means et cetera. So that may be an approach that the group wants to take.
Okay, good.
Yeah, I'm okay with that approach as well, if that's what we've done before. Maybe we should start drafting and then we can move it later.
You can look at rule 1.8.3, the gifts from client rule, which does exactly the format that Erica describes. The last paragraph of this rule says, for purposes of this rule, related persons includes a person who is, quote, related by blood or affinity. And then, that effectively it has parity with the terminology section in 1.0.1. At least both definitions are black letter rule text. It's not one residing in the comment and one residing in a rule.
That makes sense. So perhaps we should move this up then and use that similar language for purposes of this rule. Personal knowledge means.
So Sarah, do you want to take this out of the comments?
Yeah.
Is that right? Okay.
And then we would put it, let's see.
As D.
Well, oh, you think it's D? I didn't know if we should do it right after we refer to it in A. Or what was the practice? This example you were looking at, Randall, would we put it in D or A, you think, somewhere?
In the gifts from client rule, it's just the last paragraph, but it's a short rule, so it comes after the language of prohibition, A1 and 2, that's where the definition appears. So I think you can put it reasonably either as a new B or as the last paragraph B. I think you have your choices.
I don't have any preference. Do others? You want to
Depending on what else we do with the rule, we may just want to have a D where we define any terms that we're worried about.
Okay, so why don't we throw it in D for now? Then that makes sense. And then just use for purposes of this rule, personal knowledge. Should we say is distinct from the definition of knowledge under rule 1.0, I believe it's
1.01.
Is it
1.01F? Yeah.
1.01. Oh, 1.01F. Okay. 1.0.1. I forget.
1.0.1. Yeah.
Yeah. And means. And then Hunter, do you want to suggest some of the language based on what you're?
Information based on personal observations.
And should we say and does not include, I don't want to say hearsay, but does not include secondhand reports or maybe that's not, I'm not using the best language. But
maybe gained through your own senses, or observation seems maybe too narrow.
Gained through one's own senses, I think it hits at what we're looking at.
Personal observations gained through one's own senses and not through inferences from the circumstances.
Well, obviously, I mean, all personal knowledge may involve some level of inference.
Yeah, I know. That's such a, it can encompass hearsay and it can encompass direct observations. So it's kind of, yes. I think
this actually reminds me of something that the Great Bodily Injury Statute does, 12022.7 of the Penal Code. It says personally caused, and that's distinct from actual cause and proximate cause, and causes all kinds of issues. But I think this is going to be easy enough to apply because you've got a lot of essentially you've got a lot of backup in this particular meaning being applied in evidence law.
Here's a good definition. I just Googled this: firsthand observation or experience. And you're not reusing the sort of personal. I kind of like that.
First.
And experience.
Observation or experience, it kind of covers it. I might think that covers it all.
I don't know. I think experience might be kind of too broad. I like firsthand observation.
Especially because training and experience is typically the language used for experts who are
That
speculating.
makes sense.
That's a good point.
So much for that.
Firsthand observation gained through one's own senses. I don't know. I think that's good.
I like that too.
I
Period.
think the distinction between observation and senses is what I was going after initially, firsthand observation, or, you know, I see a distinction there. I don't know that observation is broad enough.
What do you mean? That
Well, but you can, I mean, I guess you could observe an experience, right? So if you get, but generally I think of observation as something that you're seeing.
Yeah, observation will generally be construed as any of the five senses.
Okay,
A perception, really.
okay. If everyone's comfortable with that, that's fine by me.
is firsthand hyphenated.
I think it's one word.
One word, yeah.
And then just one other minor nit is just changing rules to rule.
A question, do you want it to say means or is limited to?
I like is limited to.
I like is limited to because it suggests this is supposed to be a limited definition.
Yeah. Strictly limited to. Just kidding.
Even better.
And it appears this language for purposes of this rule, like that kind of paragraph always follows the last mentioning of the phrase. So whenever personal knowledge is last mentioned in the rule, this paragraph would come after.
We got to move it up.
So if we don't have other definition, yeah, it should probably go as right after A.
I'm comparing this to the way the other rules are, so. It's not the last paragraph necessarily. It follows whenever the last time that phrase is mentioned.
Okay, so it'd be the new B.
And Mimi, would it be a new subsection or would it be part of that?
No, it'd be a new paragraph.
Okay, gotcha.
I will remove D. With regard to the timing of the report, I think it's incongruous to have a subdivision of the rule that gets into the promptness of reporting when the rule does not require prompt reporting.
Yeah, and I agree. And just before we move to that subject, I just wanted to make sure, just kind of a straw poll, is everyone comfortable with this definition of personal knowledge? It seems like we are, based on those who have spoken, and just are there any objections to this definition before we move past the definition? I'll just say. So hearing none, then I think we should address, Hunter, you're talking about subsection B, or new subsection C now, rather.
Wait, let's go back. I think we should go look at 1 and 2. I mean, because I think Brandon and Joel, whoever was on the subcommittee meeting.
Oh, okay.
I think we broke those out pretty quickly. And Erica, right?
Yeah, I'm happy to address it if you'd like, Cassidy.
Yeah, let's just.
So if you look at the model rule, the reason, like comment 3 in the model rule, for example, the substantially, it's tied to what appears to be broader language than what is now in subparagraphs 1 and 2, right? So it speaks to the lawyer substantially every time I have to look at the rule to quote it correctly, but it speaks to the substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer. And arguments can be made, what does that actually mean, right? And what is substantially, and there's a little bit of a perhaps less clear than what we attempted to do here, which is there's direct references to what already exists in rules 8.4b and 8.4c. And there is an argument to be made that, you know, it's harder for an attorney to say, I don't know what that means, the language in 8.4b or 8.4c, because those are already rules that they are independently required to adhere to. And then substantially doesn't make sense if you're tying it directly to a rule violation.
You mean substantial question. So the ABA language is you shall report if there's a substantial question of another lawyer's commission of a criminal act that reflects adversely on the lawyer's honesty, blah, 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 or engage in conduct involving dishonesty. Is that right?
So what ABA model rule says is it just says a lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer. So it doesn't tie it to either a criminal act or conduct involving dishonesty, fraud, or deceit, or et cetera. But arguably those things would be things that impact a lawyer's honesty, trustworthiness, or fitness.
I think of that section as something that would include like observing symptoms of dementia or some kind of mental incapacity.
Which?
Oh, the one that Erica just read.
Conversely,
like not wrongdoing, but your fitness as a lawyer is in question.
So you would want, do we want to have that duty to report? Well, that's a criminal act. Another lawyer has committed a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer. How do you have personal knowledge of another lawyer's commission of a criminal act that involves those things?
You had firsthand observation gained through your own senses.
So you like
a great definition.
So how do you make the judgment call that it's the actual commission of a criminal act?
Yeah, and I know that this this rule is narrow and intended to be narrower than the ABA model, and I really support that. It's very similar to what Illinois' rule states. And I understand it, maybe it's very limited when you'd actually have personal knowledge that another lawyer has committed a criminal act, but I think there are situations where you would know. But the other issue I had with this is the language says under Rule 8.4b, and I was questioning whether that should be changed in both situations to in violation of Rule 8.4. That is how I notice Illinois uses the term in violation of when they're referring to it, and by using under, it was a little less clear to me when I read it. So that's just a suggestion.
I can speak to why staff drafted it that way, and then obviously whatever the COPRACs would like to do. Under Rule X is commonly used in California rules of professional conduct. So it's used 14 other times to cross-reference other rules. In violation of is used a little bit less frequently, but also used in the rule. So I think either option could be appropriate. And the reason staff, when this was included, drafted it to say under rule is because, and it's maybe a distinction without a difference. However, what we were looking to is that it's requiring the individual to make a very specific determination that the other attorney has violated a rule, whereas and again, it's perhaps a distinction without a difference, but whereas under rule makes it seem like there's perhaps not a requirement for them to make a judgment call that what this person actually has done did violate something.
So under, I don't know if I'm quite, I just want to make sure I understand what you're saying. So you're saying with using under, you feel like it's not requiring the attorney to make the judgment call that there is a violation.
I think that was the goal. I'm not certain it accomplishes that, to be frank.
Yeah, I find it unclear.
Well, wouldn't it be this, how is 8.4b interpreted just when, not in a duty the report context? When is it when there's an actual where the lawyer has actually been accused of this type of crime and charged and found guilty, and then they also are disciplined? Or is it just they've committed the criminal? I mean, I guess I'm hung up on the criminal act, you know, that they've committed a crime. Has the crime already been committed and determined to have been a crime, and they're arrested and found guilty? Is that what happens? So
Well,
in other words, so the duty to report would be triggered after this lawyer has already been.
I wouldn't think
convicted.
so. I wouldn't
Huh?
think so. I mean, ultimately, if you see somebody, you know, let's say they walk up to a complete stranger and they punch him in the face, you're in a state where you can say, look, that was a criminal act. I believe that was a criminal act. There's a distinction between what the system eventually, you know, if a jury eventually says, yes, it was, or no, it wasn't. I think that the criminal act itself is something that you can say, I believe this has been done. I don't think it's calling for a legal conclusion
Right.
beyond that appeared to be a crime. I think the personal knowledge part of it is seeing the acts rather than seeing the legal
Making the
judgment about the acts.
or drawing the legal conclusion. Yeah,
Yeah.
facts versus the legal conclusion. Okay. I mean,
So
but wait, but then doesn't it sort of overlap with two in some ways? I mean, you can basically report 1 and 2 at the same time, because you can have a commission of a crime involving trustworthiness and also one conduct involving dishonesty.
Right. B and C are not mutually exclusive.
Or 1 and 2. Yeah. Okay.
yeah,
Just on the under rule language, I think, Erica, you had mentioned a third option of as prohibited by. If under seemed sort of awkward, you could say as prohibited by without drawing back into this concept of I need to determine whether a violation has occurred. So you could say with 1, in other respects, as prohibited by 8.4, and 2, intentional misrepresentation as prohibited by, if you don't like under.
Well, can I ask why we're including the language from 8.4b if we're already referencing 8.4b? Why we're not just saying a violation of 8.4b? I mean, is that what you just explained? Because I think that went over my head.
It wasn't what we just explained, but the intent was to just, instead of requiring, we were hoping that instead of requiring I know we do it in other areas, like for the common example and relate to business and professions code, but the goal here was to allow for a lawyer to not have to go to another rule to see what their obligation is under this rule.
So okay, all right. The conversation that was just had is now making perfect sense.
Can I go back to what Dan was saying about the fitness question involving, so would this involve, so would number 1 require reporting of somebody who, you know, had an alcohol problem at the firm? And it may not be a criminal act though, but it does reflect on their fitness as a lawyer.
I think 2 would,
Oh,
wouldn't it?
reckless and intent. Well,
No.
No.
I don't think that would fall under 1 because 1 is a criminal act. So it has to
right.
be
So there
both.
has to be some sort of intentional conduct under 1. I mean, it both has to be intentional conduct, right?
Well,
It wouldn't just be having some kind of a substance abuse problem, it'd be something else.
And to that, I think as we read through the rule, you know, where the exceptions apply, I mean, fitness can be more than just obviously substance use issues, but where they do tie to substance use, there are exceptions to this rule that have been drafted. So I'm not.
Well, but
Yeah.
if the exception is if they're already in a substance abuse program or something, right? I mean, what about if you just witness a partner or a lawyer at the firm who's just is struggling, you know, and they haven't gotten to the point that they're in a substance abuse program, and yeah, you got to deal with it under, the supervision rules and everything else, but do you have to report that lawyer? And I would hope not, because of the, the limitation that it be to a criminal act that reflects adversity on the lawyer's fitness, but I would just want to make sure that that's clear, especially when the exceptions don't say that, it's limited to they're in a substance abuse program. So
I wouldn't interpret this as requiring reporting under those circumstances, absent.
Is practicing law with a substance abuse problem not reckless under 2?
But criminal act is modifying all of it, right?
No, it's not. I'm in 2. That's an or.
Oh, under 2, sorry, yeah.
I don't know that it would be a reckless
misrepresentation.
misrepresentation.
Yeah.
But that being said, just throwing it out there, like, if you are a drug addict and you drive, whether you're under the influence or not,
it's intentional.
It's a criminal act. So,
well, is driving like practicing law?
no, I'm just saying, like, if somebody drives to work and you also know that they're a drug addict, even if they didn't drive under the influence, like, there's a lot of stuff that can be a criminal act. But I think it appears to be very much limited to 8.4B type stuff. So there's plenty of things that would indicate somebody might not be fit to practice law, but it would not rise to the level of mandatory reporting. And I think that that's at least appears to be the purpose behind 1 and 2, as opposed to just saying misconduct under 8.4. And I might be wrong about that.
And I think if the idea is to narrowly prescribe what is, a violation under this rule, I don't think we add that. I mean, that's taken care of under competence and other rules. I'm not sure you need that for purposes of this rule. I think this rule, it seems to me intent to really address, like someone just said, what occurs under 8.4. And I think if the goal is to really limit this, then I think we should keep it in that way, related to 8.4.
I agree with you, Bill. The other thing that I was just contemplating is, I didn't get a chance to weigh in, but Cassie, you were raising concerns about the meaning of 1, and does it have to be a criminal act that's that they've been charged for, or that they've been found guilty of? And it seemed like you're expressing concern that maybe it's not clear here, and I was trying to see, are there edits we should make to make it clearer? Like,
well, I don't know that we can. If that language is coming out of 8.4, I don't know that we can clarify it in this rule without substantively changing 8.4.
Right.
Yeah. The only thought I had on that is just for 1, if we were to change it to say committed or engaged in conduct that would constitute a criminal act.
Well, generally speaking, commission, and this of course comes from an evidentiary background, but commission and conviction are generally considered separate, with commission being the act itself and conviction being the
that makes sense. So yeah, maybe it's fine as is. And after considering that, I'm still kind of torn on this under versus maybe the as prohibited by language here, but I am concerned about the judgment call issue that Erica explained. So maybe for that reason, I'm in favor of keeping it as under, although I do think that by using under, I interpret it to mean that perhaps it could be broader than Rule 8.4, which I know is not the intent.
I actually do like the idea of changing it and saying violation of or as prohibited by, because I think reading it as under, it does tend to suggest, and of course, not in a literal translation of the language, but it does seem to be more narrow when you say like this particular section prohibits this particular type of conduct.
Yeah, I agree with that.
Is anyone against changing it then to the under language to as prohibited by? I think that's what Hunter was suggesting, if I understood. And that's the language Randy had mentioned was something the state bar had considered.
I like it.
I like the change. I like it.
Okay, that'd be great. And then if we could do the same change to 2 as well.
I'm still hung up on the fitness as a lawyer, even though I agree that we need to keep the language
parallel.
Or B, yeah.
Yeah.
But I guess, you know, because of the substance abuse thing, but I think, like if you saw another lawyer walk up to another lawyer, or walk up to somebody and punch him in the face, I think you would have a duty to report that, wouldn't you? I mean, maybe. I mean, I think that's okay. You know, that's something that's, you know, that's certainly a criminal act. It does reflect.
Is this person your client? That's a good question.
Yeah.
To get into that.
Yeah. So, I mean, I'm just trying to, you know, because I mean, the goal here is to limit it to more like, you know, you're a thief, and, you know, that the lawyers who are stealing from clients, that sort of thing. Fitness is kind of an all-encompassing vague term that can, you know, imply a lot of things. But I guess since it's limited to criminal act, I'm okay with it.
And I think that
Yes,
frankly,
I would imagine that, well, fitness to practice is specifically already in the rules. And I would also imagine that there is some history of case law that puts definitions or limits around that term, or explanations of what that term means. So I don't know that we might be reinventing a wheel in the darkness here. That might be dangerous.
You mean that there are cases that interpret it broadly, and so we're opening up you know, a reporting requirement that can be broader than we intend?
I think the suggestion is if we start fiddling with the language without knowing what has been done with the pre-existing language, we could be causing more problems than we're solving.
Yeah.
Yeah, that was my exact point.
Okay, good.
So I'm thinking maybe at this point we should address subsection C, because it sounds like we're, you know, it doesn't make sense to try to, you know, tweak this language further, which is drawn directly from the rules. And C, okay, this is the issue that we discussed earlier. And I don't know if this is what Hunter was saying earlier, but I would be in favor of moving this type of language to a comment, since the rule does not have a timing requirement. But I'll let others weigh in.
I think that's right, because the model rule talks about the lack of there being any language about timing, and then they address this very issue in the comments itself, citing to several cases, but a couple of ethics opinions, one from the New York City and one from South Carolina, that talk about the very point of weighing the client's interests in terms of timing. So I think it's much better in a comment than the black letter rule.
Can we just take the ABA comment? You're not talking about comment 3, are you? It's a different comment? I didn't realize there was a comment on timing in the ABA model rule.
Yeah, well, there's so they have, well, I have the annotations. I'm sorry, excuse me, forgive me. I have an annotated model rules, and under the annotations, it talks about the issue of when to report.
Oh.
And that's where that comes into. They talk about that particular issue in a couple of the citations there. So it's.
Can we copy? What does the annotation say?
So it says one of the New York, well, it starts out by saying Rule 8.3 does not specify when the report must be made, and then it cites some cases, and then it cites a New York City ethics opinion 1990-3, and says although reporting must be prompt, some delay may be warranted to protect clients' interests. Lawyers should balance severity of misconduct and likelihood of its repetition against possible prejudice to client. And then the South Carolina ethics opinion 16-04, it parenthetically states, lawyer may wait to report opposing counsel's misconduct until conclusion of matter if immediate reporting might damage client's interests.
Okay.
Yeah, and then.
Yeah, I think it would be helpful, you know, if we're moving this to, I think it'd be helpful to move this to a comment, but perhaps if some of those, including some of those sites if they're useful. Because when I read this initially, I was wanting to see an example of how it might be applied, and if there's ethics opinions that interpret this, it'd be helpful to refer to them for additional guidance.
I can scan this, the annotations part. It talks about one says lawyer waited 5 years before reporting. This is the one about the dying prosecutor saying, hey, I withheld exculpatory evidence. He waited 5 years to do that. That was in violation of 8.3. Another one.
Oh, that was a violation? So that was a deathbed confession?
Yeah, which
We
was a
actually
violation.
have a deathbed confession?
Yeah, we do have a deathbed confession. And then it was, there's a Vermont case that talks about 9 months was too long for former disciplinary board member to wait to report partner's mishandling of client trust account. So they gave a couple of examples. But I'll be happy to scan that and send it to everyone. So that section right there.
Yeah, also, Bill, I'm also intrigued by the what Cassidy sent us in this roadmap to reform about reporting lawyers in firm.
Yeah.
And the problem of the associate trying to make sure they have got a new job before they go and report what they know in the firm. And it's, do they wait to leave on good terms with a strong recommendation, or get fired and saddled with a negative evaluation? And that may justify delay in reporting where it will cause little harm to the public. Now, I don't know how you square that with a trust account violation, such as a Girardi scale violation, but maybe we do want to give some comfort to these younger lawyers who don't know what to do.
Well, in these annotations, they do talk, there's a section that directly addresses that too, Joel. And under these annotations, it says you must report the impaired lawyer or the trust account violation in some of the annotations here in these cases. So I'll copy these and send them to everyone. I think it's worth taking a look at.
Yeah, and I think it'd be difficult to, in order to address the concern that Joel raised, I guess based on some of the information Cassie might send, it seems like it'd be difficult to narrowly craft that to provide protection to the younger lawyer in that situation. I mean, you're protecting, in that situation, you're protecting the lawyer's own self-interest as opposed to the client interest, which is just, I think that could kind of swallow the rule in a sense. You could always set, any lawyer is going to risk some repercussions and harm for reporting. The person you report will go after you, and it's not necessarily limited to a younger attorney. So I don't know how we would craft the comment to address that, the one situation we're trying to address here, like younger attorneys. Maybe there's a way to do it, but I think it's going to be difficult. But as a starting point, is anyone opposed to moving subsection C to a comment?
No.
So perhaps we can do that for now.
Do you want to, as a last comment, Sarah?
Trying to, well, maybe not, I guess so.
Yeah, I disagree with that, because I think the interest of the client is really something that ought to be addressed in the rule, not just the afterthoughts of the comments. I mean, if there really is legitimate reason to be concerned about the interests of the clients as a reason for delaying or not reporting, the interests of the clients ought to be set forth in the rule, not just in the comments. But
so here, my understanding is it's not intended to say you don't have a duty to report. It's the timing. this rule, currently subsection C is addressing the timing issue. That you wouldn't have to promptly report it in that situation where it would harm the client. Well, I understand the point you're making. I still believe by making it part of the black letter rule, you're implying that you always have to promptly report absent these circumstances. And I don't know, I prefer keeping the rule narrower and not imposing a prompt reporting duty that's not otherwise part of the model rules or other rules that I've looked at and adjusting it through a comment.
It does seem that the use of the rule and its existence would be subverted by a failure to promptly report, however. So a comment such as what we have in C that starts off with prompt reporting would be expected. But here's when you could angle back on that, would allow us to avoid a rule that says this is how long you have to report it or else you're in deep trouble. But it would also give attorneys some guidance that it's not, hey, report this whenever you feel like it. It really is expected to be prompt. But I don't know if we're getting too loosey-goosey with our expectations, to use a technical term.
So maybe, so it sounds like we don't have consensus on this particular issue. I'm wondering if we should do like a straw poll on it to see, and then just, based on what the majority thinks, we'll either keep it perhaps or move it. Could we do a straw poll on that issue? Since I know we have to kind of eventually vote on this entire rule. So Angela, could we arrange for that where?
Sure.
I think maybe if you have a way to word it, otherwise I could suggest something.
So this would be a vote to make subsection C into a comment.
Yes.
Okay.
So a yes vote means a comment, a no vote means leave it in the rule.
Yes, that would be it.
Okay.
Sounds good.
Okay, Erica, just to confirm, I don't need a motion or a second to do a straw poll, correct?
Correct.
Okay, so right now I am going to take a vote to make subsection C into a comment. Yes means comment, no means leave it in the rule. Bacon, Brown, Bradley, Chivers,
Yes.
Krieger,
Yes.
Mark,
No.
Mercado,
No.
Munoz,
Yes.
O'Reilly,
Yes.
Poindexter, Star,
Yes.
and Benola.
Yes.
So now that the straw poll's been taken, I did have one thing. We're using shall language in comment C, which might be problematic for a comment. And we may want to say something along the lines of should or is expected to, or whatever we use for comment language, as opposed to shall. That could get pretty, but otherwise I'm still with my position in the straw poll.
Okay, so the yeses have it. It's 6 yeses and 2 nos.
Let's change that to a where may. That seems more like.
Or I would say should maybe.
Should, how about should?
I think it should be, it should be an exhortation as opposed to options. So I think should is better than may.
Are we replacing both shalls in the paragraph?
I didn't even realize there were 2.
Yeah, I don't see the other one. I'm missing it. Oh, I see. Yeah.
Well, isn't it both? I mean, you should do it. If you conclude that it's appropriate, you may do it after your balance. Those before you decide to delay, you should balance those factors. And then after balancing, you come to the conclusion that you the delay is appropriate, then you may delay.
Well, but you should report as soon as practical.
Yeah.
Okay.
I think that works.
And so, Angela, can we move this to a comment now?
Yes.
And then maybe after we move it, we could change the shall language to, it sounds like people are in favor of should. And what do people think about maybe adding a C site to the authorities that Bill referenced? I think there were 2 ethics opinions, perhaps. If they're on point, Bill. If you,
Yeah. Right. Erica, I just sent you and Angela the annotations. I didn't have everyone's email address, so if you can distribute that to everybody, that would be great.
I'm in favor of including the C site.
Yeah.
If now's a good time, there may be some clarity that could be provided with the use of the word practical at the end. And I don't know if we want to make it practical is perhaps where we want it to stay, but if it wanted to be revised to some sort of balancing test where the prejudice or damage to the client does not outweigh the reporting.
yeah, I understand that. I think that would be helpful to have that additional guidance. I'm trying to think of this, just evaluate the standard we should have. Prejudice.
I think that makes more sense because it's not strictly a question of practicality.
Yeah.
Mm.
I have feedback from state bar staff with possible language. We could put it on the screen and then the group could vote just so we, or not vote, but excuse me, but you weigh in so that just in the interest of time. So Angela, let me know when you're ready.
Does the word appropriate fit?
It may. So instead of practical, it would be as soon as the potential prejudice or damage to the client does not clearly outweigh the lawyer's duty to report. I mean, clearly, I don't know if you want clearly in there and
yeah. I don't like clearly. I think clearly is more difficult and
I still think the balancing test is problematic because of a review as well as you could decide. I mean, one, anytime you're saying your duty to report, you're weighing that's a policy decision that an individual attorney may not be in the position to make. And then they're weighing it against their client's interest. Do they have a duty to inform their client that they're going to be reporting to the state bar about this? Or do we have to say they can report it as soon as it's not going to adversely affect their client?
Part of our discussion, if I recall correctly yesterday, talking about this particular issue was, what if your client tells you not to report it? Because it may impact his or her case or its case. Not sure if that really answers your question, Hunter, but
There's the Business and Professions Code that basically says you can't contract or you can't agree to not report misconduct, but at the same time that we're obviously not talking about not reporting it, but delaying the reporting. If your
Right.
client says this would hurt my case, please delay in reporting it. It,
Right.
it puts you in that dilemma of you're mandated to report it. You can postpone it, but what if there's no postponement that will ever mitigate material harm to the client?
right. Good
Yeah.
point.
I like the materiality standard. There's something to think about. But we would have a safe harbor though, right? I mean, I need to go back and look at this. If there was a violation of the duty of loyalty to report, right, you wouldn't have to report. So doesn't that give you an escape?
Yeah, so Hunter, if I understood what you were saying too about your concern over the balancing thing. So are you suggesting then perhaps maybe instead of saying the lawyers should balance or this additional language that Erica suggested, we would say something like as soon as the reporting would not cause material prejudice or damage to the client?
I think that's a better way of doing it because, I mean, and of course, my mind goes to 352 where you're talking about outweigh or substantially outweigh. And the issue we always run into is you can still prejudice the heck out of somebody, right? But the balancing test still says something comes in. Well, in this one, you could say we're balancing. All right, so we've got 51% in favor of reporting. It can still materially harm your client. So do you report now that you've done the balancing, or do you have to wait until there's no material prejudice at all to your client? And my thought would be the latter.
Yeah, and I prefer that because it just provides a much clearer standard too. Because I do think, like you said, the balancing I think it's really kind of vague then when you have to report under that standard versus I think the standard of material when it doesn't cause material harm or prejudice is a lot clearer.
And individual attorneys are not equipped for half of this balancing test. They're only really equipped to do the balancing test on the part of whether their client will be harmed, not whether the general public or the state bar's goals in meeting their purpose will be met.
Oh, yeah.
Let me throw a wrench into this discussion. Doesn't this, if now we're talking about a lawyer's duty to report, so the lawyer's own self-interest balance against the client's own interest, isn't that a potential conflict that would require disclosure and consent to the client under 1.7b?
Well, where's the self-interest?
The lawyer's self-interest. If
Oh,
I
to
don't
protect
report,
them. So
if I don't report, I'm
yeah,
going to be subject to discipline.
Yeah, I mean, I would that's the proper analysis, and that, you know, if there's a prejudice to the client, God,
Well,
every time you have a duty to report then you got to get a conflict waiver from your client, you know?
Well, if you're going to rely upon the exception of prejudice to the client, you better have a way to articulate that. You're not going to get that without talking to the client.
Right.
Sure.
You're not actually getting the consent.
Certainly a 1.4 duty there, and you would have to have the disclosure. But also, if the client says to you, "Oops, sorry, I didn't mean to cut you off, Joel."
Well, no, and then that led me to I throwing in too many what ifs, and I admit that, but what if the prejudice of the client is something along the lines of, the client says I'm having an affair with that person, or the client says that person is the trustee of my nephew's trust, or something that's entirely personal that in essence in the mind of the client forgives the violation.
Well, But doesn't it fall under the duty of confidentiality and then it's accepted anyway? Because it's an embarrassing thing for the client. And then you know, that's something you have to keep confidential. And so you don't have to report under that circumstance. You know what I mean? Because that falls under the safe harbor. You don't have a duty to report if the information to be reported is confidential and the client tells you, hey, if you tell this information to the bar, it's going to be embarrassing to me. I don't want you to do that.
But if it's confidential, it wouldn't be subject to the reporting duty, is my understanding.
Right, that's what I'm saying.
Oh, okay.
So
Wait, where does that say that exactly?
in the next comment. Or no, up sorry, but in the wait, where does it say? It's in the
It's in there.
Yeah, it's
Yeah,
in
it's
there,
in
either
there.
in a comment or
In the
All
body.
right.
Gonna comment.
I just like to take a look at it real quick and I don't have the text.
yeah, because remember we added, because I think staff just said attorney-client privilege and confidentiality was added. So it's anything, you don't have to, yeah, anything that's protected by the duty of confidentiality, if that's part of the reporting,
Is
then
6068E specifically referenced?
Ange, can you scroll up a little bit? All the way up to the body of the rule. It's where it was, it's DC, it's a little down. So it says duty of confidentiality, but Joel, we could obviously reference 1.6 and 6068E here instead.
Yeah, I think I'd be happier if it had some kind of reference like that to under the rules or 6068E.
yeah. But anyway, like getting back to Bill's comment, well, what happens if the client instructs you not to report? Well, I guess it has to do with the reason why, but if they're saying, you know, I don't want you to report because this is damaging to me, this information is damaging and prejudicial to me if it gets out, that falls under the duty of confidentiality.
Right.
I mean, I guess, you know, it's an objective test, but right? I mean, if the client says, I don't want you to really, you know, report this and it's publicly known, you know, but even then, you know.
Well, like I said, I think if it specifically referenced what confidentiality comes from, meaning within the definition of the rules and the Business and Professions Code, I think that's going to be enough. I do.
Well, that's my question. Is it, you know, when you're talking about this prejudice to the client and making this judgment call about delay, I still am in favor of having the comment in there. But it's kind of just prompts the whole question of, should we put?
Oh, no. I'm not suggesting we toss out the comment. I'm just saying that we amend the
the rule, yeah, to the
definition, the reference to confidentiality more specifically. That's all.
Yeah, well, I think I agree with that for sure.
Okay.
Joel, I think with regard to a client merely saying, could you not report this? I think 1.2 kind of handles that. If there's no legal basis, if there's no duty of confidentiality to the behavior or something else covering that, I think them just telling you, I don't want you to do this, that can't govern what you do under the rules.
Yeah. It has to be tied to confidential information.
Right.
And it has to be, you know, reasonably construed to be confidential information, even though that definition is defined broadly. It, you know, there is some limit to it.
It's sort of tricky to think of something that would be prejudicial to the client such that it would justify a delay that wouldn't be confidential.
Well, if just like Hunter said, if just the client says, I don't want you to report this and there's no reason, just don't do it, you know. I mean, you know, if it's something that has to do with that has nothing to do with the client? What if it just has to do with a partner in your firm or something, you know, although it's hard to believe, it's hard to envision why a client would care and instruct you not to do it.
Well, yeah, if you were, yeah.
Now, I'm involved in a case right now where there's been a violation, but the client wants the law firm to continue with a very defensive litigation. And while I can see that as something that's legitimately with the interest of the clients, what if it's something not directly related to the lawsuit, but otherwise of great concern to the client in terms of what they consider to be personal prejudice?
That's not confidential?
What would come to mind for me is, let's say you realize opposing counsel's doing something and you're worried that initiating a complaint of this kind might give them a reason to say, hey, I've got a conflict, or I can't do this because I'm in the middle of this bar investigation. Again, I can't think of a very good reason why, but if your client wants to continue with litigation and they think that the complaint would interrupt the litigation for some reason, something along those lines, and maybe you agree with your client, yes, if we do this, we may end up causing a delay, a continuance, a mistrial, whatever the case may be.
That's what I think is probably the most likely, if not the only thing that would not be confidential, which means it's a fairly narrow band, isn't it? Something related to the opposing counsel or another party that would prejudice one of your client's interests, but is not confidential.
Just their general interest in the litigation, like the
like
process of the litigation.
As Hunter said, if we report this person, trial is going to be delayed, for example, or something along those lines.
Yeah.
So I think setting up the standard, getting back to what we were talking about, I think putting a standard in here for what an attorney actually has to do, as opposed to just saying you need to weigh them, I think is the way we should go. So an attorney should wait until the disclosure does not materially harm their client.
Yeah, I agree with that. I think the balancing issue where you're putting it on the lawyer to decide the interests of the bar and the public versus their client's own interests. I think that's a too much of a unwieldy burden for the lawyer to have to go through, or balancing test.
Hey, Angela, could we work on modifying the comment to address those suggestions? Which I think is similar to what I was saying before. So I think based on that, we'd be say as soon as the duty to report would not materially prejudice or damage the client at the end. Would that be the language? My concern.
You have to bring forth the reasonably believes stuff as well, because that's the standard up the top.
Oh, yeah, that makes sense. My other concern, the only other thing that I wanted to raise as we're working with this language is based on what Bill said about, does this raise a Rule 1.7b issue? And in order to avoid Rule 1.7b, would it be better to just say as soon as the duty report does not prejudice or damage the client? I like material, but at the same time, if it causes some sort of harm or damage still, does that, I guess if it's not material, I still have some concern, is Rule 1.7b implicated? And if we can avoid raising to 1.7 by just saying as soon as it doesn't harm the client, or we haven't really, I don't think, resolved the issue that Bill raised about 1.7.
So would it be just right after the comma, so paragraph A where that comma is, would it now just be the lawyer should report the violation as soon as there's no material prejudice or damage to the client? Sorry, back down, Ange, within the comment 7.
Yeah, so
would you keep the balance? Because there's still a little bit of a balance that
yeah,
built in, but I think we're talking about removing that altogether to just say the lawyer should report as soon as there's not material or whatever.
I agree that I with that suggestion.
As soon as they reasonably believe there's not. Yeah.
The lawyer should report, and then this language right here.
Yeah, and then to add to what Dan just said.
How far should I take this out?
I think you delete all of that.
The whole thing.
But it'd be, so the lawyer should report the violation. As soon as the lawyer, Dan, you said reasonably believes?
Yeah, if that's the same standard, which I think it would be, because that's how you got into this in the first place.
And then it'd be, there is no material. And then you already have it, prejudice or damage to the client. So you can get rid of from duty, yeah. You just need to the client, so a 2 between damage and the.
I kind of prefer as the lawyer, as soon as the lawyer reasonably believes the reporting will not cause material prejudice or damage to the client, just to be a little clearer. Because when it believes there's no material, it could be a little, to me, it's less clear. It's broad, it's pretty broad.
Yeah, reasonably believes the reporting will cause no, or
does not cause, yeah. Will not cause.
Will not cause.
Yeah. And
do we want to say no longer cause?
Will no longer cause.
Yeah, because you start out by saying you can delay where it would be contrary to the interests. And then I think it should say, but then as soon as it will no longer be contrary to the interests, you could do it.
I think that just in terms of grammatical parallelism, that's a good idea.
the only other, the other suggestion I was thinking of for this comment is, it's saying right now that the lawyer should report the violation. I'm wondering if we should change the violation to maybe just the lawyer should report under, I don't know if we need the violation. Because we're talking about it's under paragraph A, and I have to go back up to see.
Yeah, I'm fine taking out the violation. I don't think it's needed, and it might be a source of some ambiguity.
Okay. I'm pretty comfortable with this language. I don't know that we really resolved the issue that Bill raised about, based on this type of situation, is there a duty to consult with the client and get the client's informed written consent? Because of the lawyer's own personal interest in reporting.
Well,
With the client's interests.
I don't, I think we should highlight that, but it seems to me that if the lawyer believes that there's a possibility that reporting may cause material prejudice or damage to the client, that would be a material fact.
Yeah.
It has to be discussed with the client under, what is it, the old 1.5 or 3,500, I can't remember what the.
Why don't we reference that? I mean, we say in comments, the lawyer should be, I don't know, I can't think of the language, but we would reference 1.4 and potentially 1.7b. The lawyer should also keep in mind compliance with other rules of professional conduct, such as the duty to communicate under Rule 1.4 and the duty to, and obtain a waiver under Rule 1.7 if appropriate, or something like that.
I like that.
Or for example, I mean, the lawyer should keep, be mindful of the compliance with other rules of professional conduct, for example, so we're not being exhaustive. Because there could be other rules, like reporting up in their law firm, for example, the duty of supervision kind of stuff.
So would we say something like, in this situation, the lawyer should consider the potential application of other rules, and then do like a C to 1.4, 1.7b?
Yeah. I don't know, in this situation.
I don't know if that's the right language. I was just trying to.
No, I know we need to kind of facilitate.
The lawyer should be mindful of other rules that may be applicable. See Rule 1.4, comma 1.7b.
Well, but again, to make it so that we're not purporting to put forth an exhaustive list, it ought to be such as.
Such as, right.
Yeah.
That may be applicable, such as.
That may be applicable to this situation.
Right.
Or to additional, I don't know. Just maybe applicable is fine. I don't think you need to say to this situation.
And then Rule 1.4 or 1.7b.
Yeah.
And
yeah.
I think it'd be an and.
Should, instead of so in one other instance in the rules, it says the lawyer should also consider.
And say consider.
Yes, consider.
So the lawyer should also consider other rules.
That looks good, yeah.
Oh, the applicability of other rules such as.
Oh, I like that.
Yeah.
Okay.
And rules 1.4.
Oh yeah.
I'm sorry, Cassidy.
Oh, rules should be plural. Rules one.
Thank you.
Okay. So with these revisions, is anyone opposed to the current comment or have additional suggestions?
Maybe.
Seems like, sorry, Cassidy, go on.
Maybe just put in parentheses after each 1.4, 1.7, the title of each rule, just sort of give them, the duty to communicate really is what I'm thinking of after 1.4.
That's a good idea. Yeah. can we paraphrase 1.7b as like material limitation conflict or personal interest conflict? I don't know what we want to, do we want something
I
there?
usually call it material limitation, but
Okay.
I don't know how it's used elsewhere in the rules. Can we do that?
I think material limitation is a pretty common term for it.
Okay, I would put
Can you put
conflict.
conflict at the end, Angela? Okay. So I think maybe we can move on to the next, I guess, subsection of the rules. Let's see. So now we're on the.
I'm so sorry. Can I make a comment about subsection B? Sorry, A2 is what so A1 has this criminal act threshold, but A2 has no such significance or, it's just a big deal threshold. So like every discovery dispute where someone says you did this thing, no, I didn't. If the person is being dishonest, everyone would have to be reported, right?
Or settlement negotiations.
I mean, dishonesty, I have like 3 cases with a law firm where they told me they would give me internal communications without me needing to file litigation. And then they later said, oh, I don't recall ever promising anything like that. Seemed dishonest to me.
You think lying is common in litigation?
Right. So the issue there is, and it's not just about whether I think that's despicable or not. The question is, would I be obligated?
Right.
To report? Would I be disciplinable for failing to report?
Well, that's a good question, because that's where the substantial question issue comes in, because
right,
you have personal knowledge of the guy lying to you. You were the guy you lied to. So it would technically fall within the rule, but when you have the substantial question standard that the ABA rule does in the explanation to say that, no, it's got to be a real serious violation and not just something that's, sort of generally accepted, like not generally accepted, but, common, unfortunately.
And so do we want to try to come up with a modifier that makes it like a threshold? Significant dishonesty, fraud, or, something like that, because we wanted to limit the rule, but that seems.
Well, maybe that's where you put the substantial question or something. Yeah. I don't know.
Anyhow, I wanted to raise that because it sort of occurred to me that A1 is limited in the way that we had expressed preference for, but A2 doesn't appear to be.
Yeah.
Well, and if we want to keep it consistent with those two, 8.4 B and C, a modifier is not, it's not 8.4 C. There's no modifier in that rule, I mean.
I'd like to just throw this out based on Brandon's observation here. One of the observations I made is that 8.4 has subparts A through F, and we're only dealing with 2 of them. And the first one makes sense. Like if you're aware of criminal conduct, that's probably something we should be reporting. The second one really can blow the barn doors wide open. Maybe we don't include that particular one at all and just go with the criminal conduct, or, go back to 8.4 and say, what is really something that has to be reported?
I would say take out 2 altogether. What else in 8.4 because we even talked about 8.4.1, right? Or 8.5, the discrimination rule.
Well, so do we think that lying, maybe at a high level lying, significant lying, but that's not criminal?
No.
Should that fall within a duty to report or not?
No.
I mean, and there's opinions that talk about fraud, right? I mean, like, the opinion that talks about like puffery, when there's puffery and when there's a misrepresentation of a fact. And then puffery is not, a violation of the rule, whereas a misrepresentation of a fact is. Well, are you gonna, the misrepresentation of a fact during settlement negotiations, are you gonna consider that to be a reportable offense? Like my client filed for bankruptcy when they really didn't, or they're going to, I can't remember what the example was, but yeah, I mean, I would not make that a reportable offense. I would be in favor of taking out 2, because that really does take out that scenario. Because you're not committing a criminal act when you're lying in litigation.
Fraud and deceit are both defined terms under the civil code. And they both require intentionality and malice.
Well,
not necessarily malice, but both require intentionality.
Not negligent misrepresentation.
Well, that's the point. Intentional misrepresentation does
Fraud, yeah.
sound bad. Reckless does sound bad, but negligent doesn't. But that's not what we're saying.
That's not the standard.
Well, as Hunter said, everything in 8.4 is bad. The question is, what's bad enough that we should raise to this level of requiring reporting?
Exactly.
Oh, I see what you guys are saying. Okay, I got it. Yeah, I agree.
Yeah, I think it would be simple to just, as I think Cassidy and maybe one other person proposed, to just strike this subsection 2. I do understand the concerns that Brandon raised about, dishonesty. I mean, that would require reporting almost, for people who are in litigation on a very frequent basis.
That's gonna weaponize it, at one.
But I don't know, and I was trying to think, is there a way to tweak it based on what you said, Cassidy, about substantial question? But it's much harder when we're referring to, because that was just a substantial question as to the lawyer's honesty. Here, we're referring to fraud, deceit. It doesn't really, that's not a simple fix. And even a substantial question as the lawyer's honesty, that's kind of hard to interpret when you do need to report. If someone lies more than 2 times, do you report that? Is that a substantial question? It just is. It's very subjective. It's difficult.
Can you move fraud and deceit into one? So you're you're saying honesty, trustworthiness, reflecting. Oh no, that doesn't make sense. I mean, I think that reflecting adverse, I mean, does 1 pretty much encompass everything in 2, except that it has the criminal act threshold?
That's how I read it. Yeah.
Yeah. So then I see no problem with taking out 2. If we wanted to do what, if we wanted to limit it to the criminal act aspect.
Yeah, I just looked, everything in 2 is in 8.4.
Right. But is it an 8.4B?
I always thought that this B section wording was odd because it implies that there is a criminal act that would not reflect adversely on your honesty, trustworthiness, or fitness as a lawyer. I'm not sure what that would be.
Yeah, that's true.
I guess there is something.
The DUI type cases, sometimes those types of cases that have been disciplined.
So what type of cases? Sorry.
So I think Hunter raised this really, like a DUI, for example. Does getting a DUI affect your fitness to practice? And sometimes it does, and sometimes it's not a clear.
Yeah. I'd be comfortable going with just 1 and sort of signaling also that the criminal act element is what raises it to the reportable status.
I'm in favor of that as well. When we think of the fraud and the dishonesty and the deceit, I mean, yes, that which rises to a criminal level would be subsumed under 1 and so would still be there. And that which would not rise to the criminal level, which would be more likely to be that stuff that you see in litigation, when it gets very contentious and adversarial, would not be reportable. And I think that that actually accomplishes the ends of what Brandon was saying earlier. What is the actual problem we're trying to fix with this, and can we tailor this to fix that problem? So I'm in favor of getting rid of subdivision 2.
Same.
Well, I think you're gonna get some pushback because B and C of 8.4 are different than, I mean, 1 and 2 are exactly in 8.4 B and C. And so the intent was to not make reportable 8.4 A, C, D, and E, and F.
Right. We're not expanding 1. We're removing 2. So we'd really only be focusing on those which would violate 8.4B.
Yeah.
Okay.
My only other, suggestion, and I am in favor of what's been suggested, but I'm wondering if we somehow still leave in an obligation to report fraud or deceit.
Yeah, that was my thought too, is whether or not, because that really strikes at the heart of what they're trying to get at when a lawyer commits fraud by stealing, like criminal fraud, you know.
If it's criminal.
Yeah.
But what if it's civil?
No, but-
There's civil fraud, and I don't.
Oh, well. Like
Well,
what
this is where my agreement that this all might be overreach in some fashion comes into conflict with what the obvious intent of this proposed rule is to call out 8.4B and 8.C specifically. And the chances of getting any traction with suggesting that we're taking out 8.4C might result in a pushback on all the other stuff we're trying to do, but.
Well, why can't we do it like we did with the civil rules, where we say we're striking this because of our concerns, and explain, but then provide an alternative, which we don't have, but you know what I mean? Like, remember we did that where we,
Well, take for instance, F and 8.4F, right? 8.4F, you may actually be violating the penal code when you violate 8.4F. You may be violating the penal code when you violate 8.4C, but we keep coming back to the question is, do we want the threshold for reporting to be something that makes the profession look bad and can be dirty, or do we want to raise the bar and say, if we're going to be having a mandatory report with all the potential problems that it raises, should we raise the bar for what is a minimum requirement, the minimum threshold for it? I think we should. I think Joel's absolutely right. We may get pushback. There seems to be a drive to do this, but Brandon's point is absolutely poignant with the idea that it's not about doing it quickly. It's about doing it well with the consideration to what the goal is that we want to accomplish, and moving forward and saying, look, we genuinely feel that this does not belong in a mandatory reporting rule. If that is in fact how we feel, is what we should say, even if we're going to get pushback on it. That's my feeling.
Yeah,
I agree.
me too. I mean, at
Okay.
least try it.
Yeah.
Otherwise, Brandon has to go off and send a report for his opposing counsel right now.
My only, just to counter that to some extent, my only concern is, we do have this proposed, I forget the number, SB, is it 42? So I'm hoping that what we propose is something that can effectively kind of be used and viewed as a better alternative. And if it's very, very narrow, or conceived as too narrow, does it have a chance of prevailing over the Senate bill?
Can
And
we look at
so
the Senate bill? Where's the Senate bill?
Senate bill is basically ABA model rule 8.3.
Okay.
I think it tracks the language of the model rule very, very similar. I mean, there may be minor differences, but it is much broader. It tracks, I don't think it has a judge reporting, but it has, I believe, the other language of 8.3. So because we're, you know, we have that to consider as well as we're drafting this, I want to, you know, I'm not necessarily against striking this. I just want to consider if there's something else, any other alternatives we want to consider. But I do understand the concern about dishonesty and even reckless misrepresentation. Fraud is a defined term under the rules. So for that reason, if we could say something, engage in conduct involving fraud.
You know, my initial idea before, because it hadn't occurred to me, just striking too, would be some language saying a significant or an act of significant dishonesty, or, you know, something, some modifier like that, which may be more palatable with the bar and the Senate, but I don't know what it means. So,
Well,
But then we would need a comment that explains what significant means, and it doesn't mean, you know, just ordinary litigation activities and negligent misrepresentation. But how do you even,
and I don't want to like bless lying to opposing counsel either by saying like, well,
Right,
that's just
right.
ordinary.
That's already prohibited though, under 8.4, of course.
Yeah.
Right, I mean,
True.
so it's got to be more, it's got to be 8.4B plus or C plus, you know, like there's got to be like a heightened,
But the problem is like every single thing we're wrestling with is very real, but we're going to be told 49 other states have passed the, you know, versions of the ABA rule and the sky didn't fall. So why are you all freaking out?
Yeah.
yeah, well, the
And is that just because the disciplinary committees just ignore it? I mean, I don't really know.
Well, the counter argument you're going to get is, well, we intended by the use of the word involving to suggest that it doesn't have to rise to criminal conduct.
Yeah.
So,
Right, and that's why the rule is that way, because 8.4 should not be limited to criminal conduct.
It's a little awkward to say we're deleting 2 because it involves a lot of what we do on a daily basis.
I think that it's more, we're deleting 2 because the level of burden it puts on lawyers for mandatory reporting and putting themselves in a position where if they're wrong about their report, it could put them in a sticky situation. That would be part of the burden, but the issue is the burden we're putting on lawyers to report, not the pass we're giving lawyers who remember, if it's still a violation, like obviously you still can report the violation.
Right.
It's about what we're forcing lawyers who are not the ones who are who are committing the violation to do.
That's an important distinction in my mind, because this gives somebody who does report an argument that they had to do it, right? And they can always report in good faith something if they think they need to, but then they're going to have to answer for it if it turns out to be inappropriate. This is a different thing.
Yeah.
All right.
I'm not sure that we can actually assess the political implications of what we're doing, right? I mean,
No,
that's a separate question entirely.
but then if you're looking at where the safe harbors are, I'd much rather have a safe harbor around something like subparagraph 2 included within the things that if I report it, I get some protection from this new rule from. So that's why I would leave it in.
see, I'm having a hard time understanding the protections, just because you can say, oh, I'm required to report it. But because the protection under the Business Professions Code that's referenced in the comment, that applies generally to reporting lawyer misconduct.
Yeah, I don't think having it in here would cause you to be protected. Sarah, would it be okay, because we've gone back and forth on this a number of times, would it be okay if we held a straw poll on deletion of 2?
I think that makes sense. And the alternative would be, I guess, to maybe, if we were to leave it in, it sounds like we would want to tweak it to limit it to something like fraud, or just narrower than fraud, or there were some suggestions made about the ways we could potentially narrow to, but I think we could just take the vote on whether to strike it. Yes or no. I think that makes sense. We've spent a lot of time and it's 3 o'clock already, so. Angela, are you able to take that straw poll?
Yes, all right, so this is a poll to delete section A2. Yes to delete, no to keep. Bacon, Brown, Bradley, Shivers,
Yes to delete, right? Yes.
yes to delete. Krieger,
Yes,
Mark,
I'm back to no.
Mercado,
Yes.
Munoz, O'Reilly,
Yes.
Poindexter, Star,
Yes.
and Benola.
Not that it makes a difference. I'm kind of torn, but I'm gonna go with yes.
Okay, so the yeses have it. 6 yeses, 1 no.
So then you just fold subsection 1 into A, right?
Yes,
Yeah.
I think that makes sense, Joel.
Okay.
I think, and if you just keep the period at the end right before C, it won't ruin your formatting as much.
Keep this period. Okay,
I
try that
think-
again.
Yeah.
Oops.
Yes. I hate when that happens.
Oh, Word is going to make sure you have to leave it there. So just go ahead and put it in.
Oh my goodness.
Almost.
See, I know it's
And then a shift and right arrow should do the trick.
No, it's, oh, there you go. You got it. Woo.
Like a surgeon.
thanks, Erica.
That comes out, and then you also have to delete the or.
Right.
If there's only one, we don't need the one, right?
Yeah.
That is correct too, yes.
And the colon.
It would just be one sentence, paragraph A.
Yeah.
So I'm going all the way. Am I deleting
We
the
could totally
colon?
fix this later. It's not even worth
Okay.
spending time doing this.
Yeah, but yeah, delete the colon later.
Okay.
So I think we could scroll down. I think we're at the final paragraph of the rule, which was kind of making an exception for information that's confidential, basically, just to the overall summary. Or does anyone have suggested edits to this subsection? I think Joel might have had something where he wanted the duty of confidentiality. He mentioned to refer to protected by the duty of confidentiality.
Yeah, that's where.
Professions Code 6068E.
And whatever the rule is.
And the rule, which is
Yeah.
1.6.
And again, this is a policy discussion really, but I think we ought to give serious thought to suggesting, or perhaps suggesting, a reference to 11376.5, or that kind of consideration. I don't know if that goes beyond what we're doing, but I think that that's definitely something we should consider doing. you know, when it's going to come between a person's bar license and another person's life and limb.
So let's maybe Angela, if you were able to add to just the first point, under following duty of confidentiality, should we just put in parentheses? Or do you want to write under is Professional Code 6068E or Rule 1.6?
A lot of the other jurisdictions, I don't know if it matters, but what they just do is by Rule 1.6, and then we would add and Business and Professions Code. Instead of saying the duty of confidentiality, they just directly reference the rule.
Yeah, but other rules don't have, other states don't have the concept in 6068E, which is secrets.
Oh, no, sure. I'm saying we would put both there. So it would say by Rule 1.6 and Business and Professions Code subdivision E, comma, the attorney-client privilege and so on.
Yeah.
To reference both. And then a question as to whether to add 1.8.2 as well.
Yeah, I think we should add 1.8.2 since that deals with confidentiality.
Sure. And you'd actually keep attorney-client privilege, and depending on what the group wants to do, it would be to delete the duty of confidentiality earlier in the sentence.
So could we say to, oh yeah. So could we say by rules 1.6, comma, 1.8.2?
Now, by rules 1.6 and 1.8.2, comma, Business and Professions Code.
Yeah, and then I think you're in semicolon.
Oh yeah, you're right.
Yeah. As far as the rest of I think you may have to have semicolons in the rest of the rule. So after subdivision E and et cetera.
Oh, so you leave the and in after 1.8.2, huh?
Yeah.
We're really, I don't know. We're getting into commas here. I just don't know.
So should we address, Hunter, did you have a suggested edit to the language based on the concern you raised?
Yeah, what I'll do is I'll copy into the chat the link to 11376.5. Oh, that was direct to Mimi, sorry. Well, Caesar's. Angela, I'm going to send it to you.
Okay.
Basically what it is it's a section of the Health and Safety Code that says it's not a crime for possession or use, just possession or use. That doesn't include sales and such, but for possession and use of controlled substance. You make a good faith call trying to save somebody for an overdose, or if you're making a good faith call trying to save yourself from an overdose of a controlled substance, you're essentially immune from prosecution. It would seem like a protection similar to that should be present here as well, because we've got mandatory reporting. And I don't know that it necessarily makes sense here, but if we're going to tell somebody you have to report, maybe we should have something that says if you're reporting in order to prevent an overdose or to protect life and limb, you can't get in trouble. I don't know if that's appropriate here, but that's what I thought of when I saw this substance abuse program language.
So the reason I don't know that that's necessary in light of the comment, which we'll get to, I think, we briefly discussed early, but my understanding is that Business and Professions Code section, and now I'm blanking, it's 6069, but that grants immunity for reporting lawyer misconduct. Let me pull it up already. I guess I don't have it open. I thought I did. But that's already under the State Bar Act is what I'm saying.
Right, but
And it's not limited to that particular situation.
Right,
So
but
by
in this one, the reporting party and the person suffering the emergency would be protected.
I see.
So
Okay.
if two lawyers who are buds, one of them ODs, the other one says,
Okay.
well, will he get really mad at me for reporting because he might lose his license over this? Should I just wait and see if he dies? Again, I don't know if it's appropriate here. I just thought I'd put it out there because it really is kind of a policy consideration.
Hunter, I guess I have a question just thinking about it. So until today, I didn't know about this health and safety code section, but so is it to say that like, if it protects the other individual who may has drugs in their possession or has been using drugs, right? So is that the purpose of it, so that they're not afraid to call like 911 if?
Yes. Now it's been a while since I've used it, but I'm fairly certain it protects everybody who's there, so that people seeking medical attention are not worried about getting in trouble for the possession. That's why I sent it out, because it's been a while since I've read it. I think it's probably been 6 years since I've seen it come up, so I haven't been doing a lot of drug cases. But
Hunter,
yes,
yeah, by doing that, do we
subsection B.
do we eliminate any other things that none of us are thinking about right now that might have the same kind of effect? And is it better instead to just leave it with the other rules or laws? I feel more comfortable not knowing even what that law is and what other laws, and not knowing what other laws might be out there which have the same kind of protections. If we single out one but not the others, we're doing something we shouldn't do, and instead just leave it by all other laws, rules and laws.
I guess I'm having a hard time figuring out how it relates to this rule, in the sense that like it seems like it's a safe harbor to not report drug use or possession when you and someone else are using or possessing drugs together. And so is it the situation where it's like two attorneys doing that, and because you're doing it together, you're not going to then tomorrow go and report that attorney?
No, it's not that. It's
Okay.
The issue that I'm seeing is that we're talking about criminal conduct, right? Because there's a specific section that basically says you're immune from prosecution when you're in this situation, either the one seeking advice or the one undergoing the OD. Should we point out that there may be laws that cause immunity from criminal liability? I don't know that makes it not a crime and not reportable, but it's just something that came up, and I think Joel has a good point in that, maybe we don't have to specify every single code section that might have a policy interest in this area of law. But
yeah,
because
I
we're
feel
talking
better that
about,
way. And then if there's people who know of other exceptions and that's why they're not reporting, and they can support that under the other rules and laws, let's just leave that.
and it might be better to talk about it in a comment or something, that there may be other rules or laws that, would make it non-criminal or something along those lines. But
No, if we're going to create this exception for those things, and there's other rules and laws that ought to be in the rule exception, not in a comment. But that's why I would just not insert what you want for that specific thing, not knowing what other specifics are out there, and just leave it to other rules and laws and give everybody a chance to fill in their own rules and laws if they feel they have to.
I'm fine with that as well. I'm not saying we have to mention this stuff. I just put it out there that there are policy discussions about when you learn of criminal conduct in ways that it should be protected because there are more weighty policy considerations in play, like protection of life. So I'm fine with that, Joel.
I would agree with Joel because there might be other things out there and you wouldn't want to foreclose them if there are.
Well, I wouldn't foreclose them, but it might appear to foreclose them by.
That's what I mean.
but
Yeah.
Not all.
Inclusio unius est exclusio alterius. Yeah.
Right. Exactly.
Yeah.
It's the argument anyway.
Yeah. So I'm good with it the way it is.
I support those reasons as well. Are there any other suggested edits to this final paragraph? Thinking maybe we should dive into the comments because we don't really have a lot of time. I think one, unless others feel differently, that doesn't seem controversial.
On one, there's only just one real quick, whether or not we should call out, there are now in 8.4.1, there's a self-reporting requirement. So I don't know if we want to say under these rules, meaning all of the rules of professional conduct or the State Bar Act, and add a reference to 8.4.1. I think that's the only rule that has a rule versus statute that has that requirement.
I think that's a good idea.
Yeah.
So in line 27, it'd be under these rules or, and then it'd be CEG rule. Oh, I'm sorry. Keep deleting. In the existing parenthetical further down in the sentence, or I guess the next sentence, it'd be CEG rule 8.4.1.
Can we put subsection D? Is that the?
I think that's right. I have to look at it again.
That's the one, a lawyer who's subject to of a state bar investigation or proceeding shall promptly notify the state bar. I think that's what you're referring to.
Yeah. And then I think you could just put a semicolon.
Okay. What about comment 2? Are there any concerns about comment 2?
Well, wait. Paragraph. Oh, no, that's right. Yeah.
The CEG for 8.4.1, should it be D and E? E is a self-reporting obligation. It's just not to the state bar.
Yeah, I think since we're not referring to reporting only to the state bar, it makes sense to reference both.
And I think to Joel's point, I think the reference in comment 2 is to paragraph C, not B.
Yeah.
But I'd have to look at the top again.
Well,
Well, this would be C right here.
So it's to paragraph C.
I think we need to just, the second sentence should be clarified that with, should be maybe with respect to rules 1.6 and Business and Professions Code 6.68E, a lawyer may encourage a client to consent to disclosure. Because the client can't, that doesn't relate to the substance abuse program exception. Right?
To Cassie, to what you just said, there was thought about separating, not to go back to or to paragraph C, but there was thought of separating out those two aspects of it. So to have it essentially be C1 that indicated that it didn't require or authorize disclosure of information related to substance use and mental health issues. And then have it be C2 for the required disclosure of the information obtained under the duty of confidentiality or protected under the duty of confidentiality, privilege, and other rules or laws. So I don't know if that would help for this comment, and I don't want to make us go backwards, but.
So do you guys want to separate C into two elements, or just clarify the second sentence of comment 2 that it only relates to the duties owed to the client of confidentiality and privilege? I don't have a preference. Everybody looks bored.
I think we're just a little exhausted, It wears you down a bit, right?
Where it would otherwise violate a lawyer's duties to a client, something like that would work.
Perfect. Oh wait, how do I encourage a client to consent to? Well, yeah, what is this? A lawyer may encourage a client to consent to disclosure, provided the disclosure would not prejudice the client's interest.
So really, it's what
I
we
find that, sorry, I just find that problematic. You're like, that goes back to the conflict question, right? You're like telling the client to, consent to this duty to report. Well, I mean, I guess if provided the disclosure would not prejudice the client. I don't know. I think that just opens up a whole can of worms that the lawyer is then now being asked to pressure the client to consent after they've, determined that it doesn't prejudice the client's interest. But that's a, that's a whole other burden.
If what your conclusion is that if you make the report, there'll be a lengthy continuance of the litigation that'll prejudice your client, the client's not going to know about that. And why are you going to convince the client, well, let's go ahead and accept that prejudice?
Yeah.
And if you've decided that it doesn't prejudice the client and it's just you fulfilling a duty, why would the client weigh in on it at all?
Right, to consent.
They have to waive their confidential. I'm in favor of striking this comment.
Me too.
I don't think it's necessary because I didn't really think of that until you started evaluating it, but it's a good point.
I think we already beat that one up with.
Well, it's in the other comment, I think it's taken care of there because you're going to have a conversation with the client. And in the course of that, there may be consent, there may not be consent, but I don't think that you should try to persuade the client one way or the other.
Yeah, I agree.
So I think the proposal would be to strike this whole comment because I think the first sentence is unnecessary. It's already part of I think it's clear under the black letter of the rule. So I think the proposal would be to strike 2 altogether from understanding. Does that make sense?
Yeah.
I agree.
Yeah, because that's what, yeah, exactly.
I'll just ask rather than doing a straw poll. Is anyone opposed to that? Striking 2? Okay. So let's go on to 3.
Oh, okay, here we are. All right, yeah.
Yeah, this is your expert, you know,
Yeah,
somebody.
yeah, okay, I overlooked that. Yeah, okay, right, that's good, all right.
The last sentence is from the model rule. I don't know if it's really necessary.
It could also imply that expert relationships are an attorney-client relationship in all cases.
Yeah.
Take it out.
I think so.
Okay.
So just, I had to read, when I was looking at this in preparation for our meeting, I had to read it a couple of times to understand kind of the nuances. And maybe it's because I wasn't, you know, I don't know. I'm wondering if we could be clearer. I'm just looking at it again. Maybe
What are you on now, Sarah? Which one?
I just, for some reason, when I read this initially, I was having a hard time tracking. You say, does not apply to a lawyer retained to represent a lawyer whose professional conduct is in question. That makes sense. To a lawyer who consults with a lawyer who is a potential client and whose professional conduct is in question. That's the part that I was trying to.
And that's not in the model rule, just so you're aware. It's limited to actual attorney-client relationships as opposed to potential client relationships.
Yeah.
Yeah, but the privilege of what 952 applies to pre-retention communications where someone is seeking representation. So I would leave it in.
Oh yeah, and I'm not suggesting we don't leave it in. I find the language difficult to read is all I was saying.
Oh, okay.
I was just trying to see if there's any way we could improve it.
Just say it does not apply to a lawyer who is consulted about or retained.
Yeah, because it
Yeah, I
just,
think that's
just
that is
potential
clearer.
clients it's trying to get at.
Yeah, exactly. Because when I was reading, I don't know, I might have just, I was having a very hard time with the second. So then we wouldn't need to a lawyer who consults the lawyer who's a potential client whose professional conduct is in question. That language.
Right.
Yeah, okay.
Should it be limited to professional conduct? Or should it be a little broader than that?
I think it should be broader. That's,
I do too.
I mean, it's not always just questions that are limited to professional conduct. Our clients are lawyers, so we see and hear a lot of things.
Right.
Yeah.
So what do you put in place of professional conduct? I mean, all the things we've been talking about in 8.4.
Whose conduct?
Yeah, it was all about professional conduct. So I don't know that it's wrong to say that. I think that includes everything.
What about just conduct?
Yeah, it was I don't think we were talking about professional conduct as much as conduct that, you know.
Yeah, what about the
It
guy
was
who punches a
unsuitable.
guy at a bar?
Right,
Right? Yeah.
right.
I punch somebody at a bar. Am I gonna be, do I have to, what's gonna happen to me?
And is it the conduct, you
Well,
know,
I guess it's professional conduct.
maybe conduct at issue? I think that would be
Right.
okay.
Yeah.
Conduct is in question, conduct at issue. Conduct is in question, is that what you're saying?
I don't know. I wouldn't be in favor of putting in the at issue only because
Yeah,
you
you're right.
learn things during representing a lawyer that may not be related to
Right,
that came through the door.
right.
Well, I agree with you. I was with that issue. I was kind of getting to an issue with respect to the disclosure obligation and taking it out of the representation. At least that's what I was trying to do. I
Well,
think that's right.
You're saying strike professional.
Yeah.
Yes.
Okay.
But does the conduct have to be in question? That seems like you're consulted
It just has to be part of the lawyer relationship, you know?
Exactly. That's really the issue.
It's got to be I mean,
Can we just say regarding the lawyer's conduct?
Yeah,
I mean,
I guess the issue is, does the representation have to be about the conduct, or do you learn about it? You're not going to report on your own client.
yeah, they're telling you
Better
about
not you-
something, and
yeah,
then
if
they
you don't-
say, yeah,
Right.
and then they say, and so I stole some money out of the trust account.
wait, that doesn't happen. That's never happened.
But, you know, an offhand comment that they were talking about some, you know, like, would you have, you couldn't have a duty to report at all, anything that your lawyer client tells you, I would think. Well, I'll take that back. What if they like killed someone? Anyway.
If they did, is it confidential?
Yes.
They're
They're
dead.
about to kill someone. It's different.
Yeah.
That's
Different
different.
if it hasn't
Yeah,
happened.
if they're about to kill, right, I know. Here's the
Okay.
bloody knife.
Okay, folks, this has been a
Sorry.
little slice of heaven, but I gotta jump off now. You're doing great work. Keep it up. I'll see you next time.
Bye, Joel.
Yeah, Joel.
Right, Joel.
um,
Okay, does not apply to a lawyer who consulted about or retained. Who is
I liked Sarah's regarding. That seemed to be okay.
so to represent a lawyer regarding their conduct or regarding the lawyer's conduct.
Yeah, I mean, in any way. Pretty broad.
That means the representation has to relate to the conduct, right? So they're not just telling you something during the course of the representation. That's the problem I have with that modifier.
Yeah, I don't think it should be limited to that.
the other thing though is the rule already doesn't apply to something that's covered by the privilege or the duty of confidentiality.
Right.
So that would cover, in my mind, what you're concerned about, Eleanor, but so I'm just.
And
Well,
our
what's the point of
personal
this?
knowledge definition, I think, takes care of the question of, well, if they tell me about it, do I now know about it? And do I have to report it? So the personal knowledge requirement prevents it from becoming a daisy chain of reporting requirements.
Right.
Yeah, what's the point of 2 if it's covered by the confidentiality?
Well,
Yeah, maybe we just take it out. Feels like it's muddying the water to me. It feels almost like a limitation when you read it. Maybe something just more expansive.
Right, because the confidentiality would also already apply to potential clients, and that's not the issue.
Yeah, what?
I mean, I guess, well, no, because if you learn it through the duty of confidentiality is so broad. I'm just trying to think, is there a situation where you learn something through the representation that wouldn't be covered by the duty of confidentiality or the privilege?
Right, well,
What would that be? What would be excluded there?
if there's been a waiver or if there's been,
Well, I mean, it's arguably things that aren't, for the purpose of providing legal advice, right? So you can definitely get outside of the privilege.
the
and
privilege,
their
yeah,
client. Yeah,
but
communication.
not confidentiality.
Confidentiality, though, is much broader.
That's true. Yeah.
And I think my thought is that anything that would rise to the level of reportable would certainly also be confidential. That's my thinking.
That seems right. I mean, well, I guess there you have it, is like if they've told other people. It was
Still confidential
Still
as us.
confidential,
it's
yeah.
still fault. Yeah, you're right. It's still fault.
I don't know, I feel nervous about getting rid of it, though.
I
don't
know,
why.
I'm kind of torn. Erica, do you know, like, is this something that was, or the working group, I'm not sure where this language came from, but is it something that was part of another rule, or why we, the purpose of this here?
I apologize. I was answering an email, so I apologize. But the olive comment, what is now comment 2, or?
Yes.
So comment 2 exists in the model rules. So what is now comment 2? So the the only language that was added was what has now been clarified with the who is consulted about language. Otherwise, the majority of the comment, I can tell you which comment it is in just a moment here.
Does the model rule also have, it also has the confidentiality exception, right?
Yes, it does. So it's a clarifying comment. It's not I mean, all comments are supposed to be clarifying, right? They don't create any additional authority, but it's existing. Let me see.
What I like about it is that I mean, if we can rehabilitate it, it describes excluded relationships, not just excluded information. And so in that way, it feels broader. It means if you represent a lawyer, this isn't for you.
Yeah, exactly. It's like, it's.
Yeah. So then for that reason, I'm in favor of keeping it over striking it as we were contemplating.
Right, because
it protects us.
Right.
I'm just still seeing if there's something else we want to say besides, I know Eleanor raised a concern about regarding their conduct being.
So ABA Claimant 4 limits it to the duty to report professional misconduct does not apply to a lawyer retained to represent a lawyer whose professional conduct is in question. Such a situation is governed by the rules applicable to the client-lawyer relationship. So it doesn't include what is now the last clause of the only sentence, which is the ability to consult on whether or not the lawyer has a duty to report.
Angela, just because I know we're still tweaking it, but could you strike is in question? Because I think that was intended to, I don't think we need the is in question with the other revisions here.
I mean, we want it to exclude the lawyer representing another lawyer, but not in something that doesn't involve a reportable thing, right?
Eleanor, do you have suggested edits to address the concern you raised about how you would reword this?
I don't have them yet. I'm looking at it.
I mean, we could say does not apply to lawyer consultations, period. About whether to report. No.
So if you represent another lawyer in a real estate dispute with their landlord, that's out. Or divorce.
Right. No, that's, I mean, I know it's in there. Yeah. Well, then I think then it comes back to about their professional conduct. I mean, you are going to be consulting
but something like in connection with their professional conduct, that's something like that. So that's not just what they came in the door about. It could be anything that would be reportable would be in connection with their professional conduct.
So retained to represent a lawyer. Retained to represent a lawyer in connection with their professional conduct.
Yeah, although that doesn't solve Eleanor's problem because it links.
But I think that's what we're talking about.
Well, if you're representing somebody in connection with something else and you find out something that would be reportable, do you want that to be included here or excluded?
Okay, so you're representing a lawyer, right?
In a divorce.
In a divorce, yeah. So that would be included if they said, if that lawyer, in connection with the divorce, they could be, they filed a false tax return.
Right.
And you learn that as part of the representation. Do you have a duty to report? No, not at all. I would think, but that has nothing to, but the subject of the representation is not necessarily about the lawyer's professional conduct. It's about the
That's right.
divorce.
That's the issue, because if we're linking it to the professional conduct, then that information wouldn't be disclosable here because of the confidentiality. But we want to say something about lawyers representing lawyers in lawyer questions is excluded as a category. I think that's our thing.
Yeah.
but how best to say that?
Right, okay, but right. But then it goes back to, then I think it's fine in connection with their professional conduct. Is that?
The only reason I think it's not quite there is because you are retained to represent the lawyer in the divorce.
Just say whose conduct would be the subject of the complaint or the reporting.
Yeah. Yeah. That
Oh,
probably,
whose conduct would be the subject. So, right, so they're not, that doesn't necessarily mean that it's the subject of the representation. It's
Right.
just, it's the subject of the report. I think that's good. Can we put that in writing?
Yeah, can you say that one more time? Representing a lawyer whose
conduct would be the subject of the report. I don't know how we're saying it to make it parallel throughout. Look at the other paragraphs, but
Who's consulted about or retained to represent a lawyer whose conduct. I still think it gets back to like Sarah's initial, like, I'm reading this going, what? But I think it's hard to figure out the most direct way of saying this.
would it be possible to just reformulate and say a lawyer doesn't have a duty to report under this section if the client is another lawyer if their client is a lawyer? That doesn't work, sorry. Just trying to exclude and simplify the category we're trying to exclude. You know what it is, it's just difficult to say it.
It does not apply to who is consulted. I mean, we could eliminate who is consulted about or retained to represent a lawyer. Those are I mean, we can say that more simply. Or retained to who is consulted about or retained, who consults with another lawyer. Wait, who?
Yes, I just have to step out for 1 minute. I'll be right back. But if you can still mull over this.
Okay.
Does that added clause actually change anything in the rest of the sentence?
Consulted by a law. How about does not apply to a lawyer whose conduct. I can't figure this out.
Does this maybe belong in the other comment where we just say, you know, where your professional duties prohibit the reporting? Or other laws prohibit the, you know, confidentiality?
Well, can we go up?
I think that would make it clearer. That's kind of what I'm struggling with.
Wait.
Oh, you mean it's in the, okay, this is,
I don't know.
it's not a comment.
No, you're right. You're right. I'm not sure. I mean, this is just a clarification of C.
Yeah, basic. Well, it's somewhat of an expansion of C. Well, no, what is it? It's an exception. It basically states an exception, right? For the type of like a category.
It's an expansion, it's broader.
Mhm.
An exception is broader.
It doesn't seem like we can do that with a comment.
Right, but they do.
Yeah.
The ABA does. I mean, there's other, I'm thinking about, where, like where you're allowed to consult with your in-house lawyer or an ethics lawyer about a problem with the client without having, that's confidential as to the client, you can go and talk to, and that's, I mean, that's not in a rule, but that's similar here. And I guess that has to do with the confidentiality. Maybe we just keep the language similar to the ABA rule, and because it's, because I bet you, do all other states have this comment? If they have, who have adopted the ABA rule?
I'm just looking at, I don't know about the answer to your question.
It was rhetorical.
But I was just looking at the Illinois one, which actually is very similar to the ABA, but the Illinois rule tracks our language a lot more in the substance of the rule, but it just says it's very similar. Duty to report professional misconduct does not apply to a lawyer retained to represent a lawyer whose professional conduct is in question, or to a lawyer consulted in professional capacity by another lawyer, and whether the inquiring lawyer has duty to report a third party lawyer's professional misconduct.
So they just adopted the same terrible language. That is, I mean, it's understandable, I guess. So that's what it's really hard to come up with language. And so maybe we want to keep it consistent so that it's interpreted the same way as all the other states, you know what I mean? So that if there are interpretations of the rule and references to that comment, we would want that same interpretation. But I just don't know.
Yeah, I view this comment as really intended to address a situation where a lawyer is consulting a lawyer about compliance with the rules or compliance with the law governing lawyers. That's how I view this.
Yeah,
the intent of this comment. So the original language, I think, is sufficient to address that situation. It's not,
we're broadening it. I mean,
I think that's the revised language, I think, is intended to broaden it.
Yeah.
But I don't.
Can we do that, or should we do that? Is the question, I guess.
Yeah.
I mean, I suppose I'm fine the way it is, if that's as far as we can get it. I mean, do we have opportunities to revise? I mean, we're gonna have opportunities to revise the language after public comment, right? I'm sure we're gonna get a ton of public comment.
Yes.
Or revise our proposals, I guess.
I hate to throw this out, but I think the consulted doesn't work as well. The consultation, you would think that would have a limited confidentiality obligation, right? So if the consultation is not about the conduct.
What do you mean?
Yeah,
I think as we're expanding it, we're saying, we're kind of getting to the lawyer-client relationship, really, but the consultation is going to be a narrower obligation. That makes sense. I'm almost in favor of reverting back the more I look at this. And maybe we just, I don't know, maybe there's a way we can be clear that it's intended to apply to lawyers, consulting other lawyers in connection with their.
Yeah, I mean, at a minimum, we want to say, yeah, we want to protect those types of consultations where they are worried about having committed a crime or whatever. I mean, I'm kind of in favor of reverting back to the language, to the ABA language too, just to, if only just to keep it consistent with what other states are doing on, at least on this part.
Yeah, I favor that too, although I still would like to have it apply to potential attorney-client relationships.
Oh, yeah.
Consultations. So I wasn't sure if that was the proposal to remove but I think it should apply to.
I think if we revert but leave who is the consultation, it's fine.
Okay, yeah. That makes sense. What about others?
I agree with that. I think it's, when we first read it, it's not the clearest way, but it is intended to exclude the category that we want, and it's consistent, so that's helpful.
So we're gonna go back to the.
Tell me when to stop.
Okay, so delete regarding there, so don't accept
Regarding
that.
there, okay.
And then I think we're gonna keep whose professional conduct is in question, right? So I keep is in question.
I would probably still take out professional, but.
Whose professional or whose conduct is in question?
I would say whose conduct is in question.
I kind of agree with that too.
I would go
No.
for that.
And now I'm like going back, I'm like, well, maybe we should.
So whose conduct is in question, and then, okay, I think the rest works. Wait, yeah.
No, you want to, well, we want to keep the potential client, right? To a lawyer who consults with a lawyer who is a potential client.
Well, don't we have that?
Yeah, consulted up on top.
Oh, okay, wait. So who is consulted is encompasses a potential client?
Supposed to be, yeah.
Okay.
Consulted about or retained.
Oh, I see. Okay, all right, got
So that was the intent.
it. Okay.
I'm just gonna circulate something. If we felt like we wanted to clarify it a little more, we could add that, although I'm just a suggestion. I don't feel strongly about it.
I apologize. I need to actually depart as well. So I applaud everyone's excellent work here. If I can vote in abstention to approve what we've worked on so far and whatever you guys do in the next few minutes, you have my support.
I think, I'm not sure we're gonna have a quorum.
That was my concern.
Oh,
Yeah.
okay.
Yeah.
Let me just shoot an email then.
I
Sorry.
was about to say that, Erica.
Not a-
Oh, wait.
So I don't know. Can we vote on this? Because I mean, we're almost there before. Do we need Brandon for the quorum then?
Just don't rush on my account.
I actually really, Eleanor, I saw your chat and I really like that addition because I think it really makes clear the point of this comment.
Yeah.
So I don't know if others have had a chance to look at what she put in the chat, and Angela, if you can see that, but I think that would be a great addition.
I agree.
I agree.
Where would you like me to put Eleanor's edit?
I think it goes to the beginning. So the duty to report under paragraph A, and then you would say, right, oh, I'm pointing to my screen. After A, that's how tired I am, is not intended to discourage.
Okay, got it.
Yeah. Oh,
No, actually, I
that's
think
already there, but that's fine. Yeah.
yeah, you changed this to the, sorry.
So now there's just get rid of one of the does not apply. We have two now. Okay, yeah, that looks good.
I like that, yeah.
And so I think there's only one more comment. Am I right? Comment 4? Oh no, sorry. There's a lot more. All right. I was hoping we were almost there. Okay. But I think, hopefully the rest isn't as controversial. Can we move on? I think this comment 3 looks good. 4, I'll pause. I do not have any comments or concerns with this particular comment.
That looks good.
It's
Looks
fine.
good.
All right. 5.
I think 5 looks good too.
Yeah.
Mm-hmm. Good.
Yeah, that's right. Okay.
Okay, so this was the one that deals with, I mean, it's kind of unclear because we're just having a C in a comment. But I feel like we need some sort of intro sentence to this comment or something to explain why we're having this C reference, but the sites are dealing with a lot of different situations, so I'm not sure if there's a catch-all kind of intro or something that we could put in here to explain the purpose. This is kind of like the analogous to what we said above is, I forget the language we use, but the lawyer should be mindful of other applicable rules, CEG, and then cite these. Because to me, I don't know, maybe I'm the, but I find it strange to just have a comment that just says C.
Yeah, what's the point here? So we're,
But this does have 6094, which is the important one that I think several people have mentioned about the kind of privilege and immunity about communications relating to lawyer misconduct.
Is the point that the reporting does not remove your obligations under 8.4a or potential exposure?
what, yeah, what, so what are you trying to tell the person who's considering reporting and they're going to the rule?
I'm confused, yeah.
Yeah, so I have to report something. What's my obligations? And then see rule 8.4. So if you don't report, are you going to be assisting the reported violation? No, right? And then if you so if you're on agreements that preclude, right? So
You know, I don't understand the 8.4a. Maybe if we could reference. I don't know how that applies.
well, yeah, I mean, so if you don't, well, that's my question. If you don't report, if you read this rule and say, oh, I have a duty to report, and you say, and then you say, I'm not going to report. I'm making a decision. I'm not going to report. I'm going to violate. Does that also, you're electing to violate 8.3, and then are you also violating 8.4 because you're assisting that lawyer, the lawyer's violation in some way? I mean, what's the, if the violation has already happened?
Yeah, I would be in favor of removing the reference unless someone has a reason why they think it's helpful, removing the reference to 8.4a here.
So I think one of the reasons why it's here is because if you do a Westlaw search and look for cases where other jurisdictions have applied their 8.3 rule, it often arises in sort of low-hanging fruit situations where the bar prosecutor went after 2 or 3 lawyers, and they were all co-conspirators in the misconduct that they engaged in, and then they tack on the
reported.
you were assisting the other lawyers in their misconduct, or you were inducing the other lawyers in the misconduct. And so it's sort of an odd, I don't want to say an odd phenomenon, but that the reporting rule is used when the lawyer already has engaged in other misconduct as a co-perpetrator with another lawyer, and each of those lawyers' participants are charged with not reporting each other. Well, of course they didn't report because they were all hoping to get away with it.
Right.
Okay, I see.
So it's
There
basically
is
like,
a relationship between when lawyers are assisting each other in misconduct and how this rule actually operates in actual prosecutions.
all right, then I think it's important.
But I agree, it's kind of odd in this one paragraph, the comment paragraph, to just lump all of these things together. It also obscures the import of the immunity and the juxtaposition with the false and malicious complaints. Those two almost deserve their own comment, I think, to make sure that they get the sort of recognition that they deserve.
I think that's a great idea, to move the reference to a new comment, especially since I think many of the members really seem concerned about the safe harbor, and I think highlighting that, because right now it's really difficult to follow. So
Yeah, and I think the 8.4 and 5.6 kind of go together because they basically have to do with agreements between lawyers to do bad acts, and they really should be reporting on each other.
that's a
One
good
is,
point.
you know, I agree not to report, you know. So those two can go, but I think we just need an introductory sentence to explain why we're, you know, what the point of 6 is.
Yeah, so for now, is anyone opposed to moving, starting at line 60, C, Business Impressions Code section 604, 3.5, and the rest of that sentence to another comment following comment 6?
Nope.
So why don't we go ahead and move that now? Thanks, Angela. And then I think now what we need to do is probably work on some introductory language for both comment 6 and comment 7.
Yes.
So let's see.
You're all 8.5.
Maybe the easy one is new comment 6. And I think you would flip the concepts. I think you start with the privileges and immunities, and then you use the descriptor from 6094 to get those magic words in there for no action shall be predicated thereon. But then the ending topic of the same comment is, but, you know, this immunity doesn't extend to things that are false or malicious in terms of reports to the state bar. And that's, I think, the 604 3.5.
That makes sense. We could do like a but C after we refer to 6094. So I guess
those who would weaponize it would say, aha, 6094, I can do whatever I want to report this in the most warmongering way I can, but then they will be caught in their tracks by 604 3.5, hopefully.
Yeah. Just pulling up that language to see if we can. I think you had it pasted. Let's see. So can we say lead in with communications to the state bar relating to lawyer misconduct?
Actually, Angela, I think that goes to the comment below. So the next comment.
Okay.
The new 6.
Yeah. And then if we could add, oh, I had it open in a second. Let me find it again. I lost my screen. Okay. Are privileged, and maybe we could put this in quote, are privileged and no lawsuit predicated thereon. I don't know if we need to quote it. Maybe instituted against any person. That's the quote, but I'm wondering if we should paraphrase instead.
I guess the one positive of quoting it is that won't be accused of putting any sort of spin or gloss on the protection that's afforded. We're just saying this is what the existing State Bar Act law says in terms of what's protected.
And yeah, that makes sense. And the only other question I have is the first part is not a complete quote. So I just want to read this so everyone has it. It says communications to the disciplinary agency, which I think it's okay to say communications to State Bar, that it says relating to lawyer misconduct or disability or competence or any communication relating to an investigation or proceeding and testimony given in any proceeding. I don't really think for purposes of this rule, we need all of that. But I'm wondering if we should keep in or disability or competence, although I'm not sure if it in here as well.
I don't think it's necessary.
The competence, I mean, it might fall under the fitness part up above.
Title of the rule of misconduct. I mean, I don't know. It seems like
it's defined with just misconduct. Yeah. And I mean, we're saying C. Okay. So then I think the reference, it should start with, it should say C Business Suppressions Code, section 6094. And then I think we could just put a semicolon and then say, but C. Is that the right? And then I think we could delete kind of after false and malicious complaints, delete the rest because we addressed that up front. And the only question here is I haven't pulled up 604 3.5. I don't know if that's sufficient, how we just paraphrased it there, or do we want to quote something? I can try to pull it up real quick. Or if people think that's fine, I don't need to, let me just say.
We should look at it because I think it's expressed as exposure as opposed to prohibition. You're exposed to criminal charges.
Okay, so I probably should pull it up on Lexis, but based on my Google, every person who reports to the State Bar, or I'm not saying we should put this, I'm just reading it. Every person who reports to the State Bar causes a complaint to be filed at the State Bar that an attorney has engaged in professional misconduct, knowing the report or complaint to be false and malicious, is guilty of a misdemeanor. The State Bar may, in its discretion, notify the appropriate district attorney, blah, blah, blah. Okay, and recommend prosecution. Okay. So, what did we say? Yeah, it's,
Did it say with respect to punishments for false and malicious complaints?
yeah, I was thinking, yeah, punishments or liability for false and malicious complaints.
Yeah, or penalty, but I don't know if penalty is appropriate because it's a crime.
Maybe we could say liability. I was thinking also maybe we could mention or potential prosecution, because the statute refers to the State Bar may, in its discretion, notify the appropriate DA or city attorney about the issue, and recommend prosecution of the person. So. Is punish when it's referring to it as a misdemeanor? I'm kind of still wondering if you be using punishments, but punishment.
I think potential prosecution is better.
Okay. Okay. All right. Does anyone else have suggested edits to this comment? So
I would probably just say with respect to false and malicious reports or complaints, you've left out reports, but
oh yeah,
potential prosecution, but I mean, it says they might recommend it, but
Eleanor, did you have other edits?
No.
I would remove potential prosecution for and just say with respect to false and malicious reports or complaints. But
oh, I see what you're saying. Not. I like referring to potential prosecution or the fact that it's a misdemeanor, just to kind of, I think it has more of a impact when you look at it and would discourage, you know, kind of abuse of the role. But
How about respect to criminal penalties for false and malicious reports or complaints? Because calling it a misdemeanor is the designation of the penalty, because in a criminal statute, it's either designated as a misdemeanor or it's designated as a felony, with the standard felony coming with a 16(2)(3) triad, or being specified further as a particular triad of years. So when something says it is a misdemeanor to do that, that is the penalty statute.
so for that, I mean, for that reason, I support using that penalties for. Is that what you're? Was that right, Hunter?
Yeah, I would say criminal penalties because it doesn't just say it's a crime, it specifies what the penalty is, which is a misdemeanor conviction. And
Any concerns with the revised language for this comment? I think we're reaching the end, because I believe 7 we already worked on at the beginning. And the rest we can probably, Angela, just so we don't strike the rest, that was just for our reference. So 9.4. So I think we're there at the point to vote on this. So
Do we want to put, take a look at Eleanor's proposed language for comment 6? The front of comment 6. I think you skipped it. I mean, comment 5.
oh, I forgot about that. Sorry. Oh no, we got Eleanor's. I thought we got it.
No, it's another one. It's in the chat.
Oh, I missed that. Let me look.
That's okay. You're busy.
Possible intro for comment 5. Oh yeah, we did miss that though. That's yeah. I didn't see any. A failure to report may also implicate. I like that intro.
Just very basic.
Yeah. Are others, anyone opposed to that intro? I think that might be the fastest way to move it along. I think we could just go ahead, Angela, if you can add that from the chat.
Or maybe we just put, or do it real 8.4 with respect to, and then maybe a C also.
Yeah, You need a space.
Rule 8, and then see also rule 5.6B in business with respect to.
See also right here.
No, put a semicolon after ethical violation in the second on line 58. And then see also there, and then delete and.
And you also need to add a space after 8.4a.
How's that?
That looks great. Well,
Do we want to put it in no markup viewing, just so we can like all skim through it real quick?
sure, that sounds good. And what I was going to say is assuming you can do this, is when we vote on it, I think we would agree to allow any kind of just minor cleanup for spacing or typos, which we might still need, rather than spending time on doing that now.
If you go and to the left of where you are, it says all markup, and just, yeah. And then exactly. And yeah, we would clean up the spacing there, obviously.
I know we kind of got through this, but just since we're here now, could we say through one's own senses to say through the lawyer's own senses instead of one's?
I'm fine with that.
Yeah. Under subsection B.
I think firsthand might also just take care of that.
No, I like senses. Maybe.
The little spacing nits and things that are coming up with the.
Yeah, like the two buys. We could
fix that later.
I think we can just go ahead and fix that later and still vote on it. Unless I'm just thinking if there's anything like that just seems something that we just overlooked in substance.
We spent a lot of time on 2, but that's still a doozy of a sentence.
It's one sentence.
Yes.
Why don't we, can we put a period after, the duty to report in a paragraph A is not intended just from seeking counsel. It does not apply. Can we put a period after?
I like that, yeah.
Just to break it up a little.
Then it's much easier to read, yeah.
It or the duty, it does not, just, yeah, it's fine.
Is this the between 2 and 3 the better place for comment 7?
I forget what comment 7 is now, but
It's the timing requirement of when you have to report under A.
Yes, I'd say move that earlier.
The rest of the comments either address the rule as a whole or address other subparagraph or paragraphs of the rule, excuse me.
yeah, that's a good catch.
But Alexia managed to send it on.
one thing that just came to mind, I don't know why, but I don't think we ever, I thought for one of these comments, we were going to add some sites to, and maybe it's too late to do so now, but to some ethics opinions that Bill had sent. Did we ever do that? I don't remember which comment it was now.
It was tied to the timing comment, which was formerly 7 and now moved up.
And that was sent out at about 2:10.
I'm not sure if there's anything more in those, I skimmed both of the opinions very briefly, and I'm not sure there's really anything else that's said in those opinions other than what we're now putting in a comment.
All right, well then I don't think it's necessary then.
I like it.
Have folks had a chance to finish reviewing yet? So I propose we vote formally on, I guess, now I understand the next step would be to issue this for public comment, subject to any just cleanup errors like spacing or typos. So that's the proposal. Erica, did I correctly portray that the next step would be to issue this for public comment by COPRAC?
Yes, so you know, if that's the will of COPRAC, what we would hope for is a initial public comment period through COPRAC. So so that the opinion, or I'm sorry, the rule could be brought back to COPRAC at its March 3rd meeting. So it would be to fit within that time frame and actually give the working group time to evaluate those public comments, and then all of to meet the Beckley-Keene requirements, we'd be looking at a 30-day public comment period realistically.
Okay.
What's the record for public comments? Because I think we're going to hit it.
And then tied to that, as I mentioned earlier, staff is hoping to have a public hearing on the rule to allow for the opportunity for those, because it is a relatively short public comment period, to allow for individuals to give oral public comment on it, and those would be transcribed for the working group and then for the full committee to consider at the March meeting.
And for the public hearing, is that something that members of COPRAC should attend, or the working group, or should I attend? I just wanted to know for planning purposes.
So I was intending to, since you brought it up, I was intending to reach out to members of the working group to see if this is something that some or all of them could attend. You know, certainly Sarah, as chair of the committee, it would be wonderful if you could, but recognizing the tight timeline of this, you know, the more individuals that can attend, the better. However, we understand that there are schedules that need to be accounted for.
Okay. All right. So with that understanding, then does someone want to move to issue this revised rule subject to any cleanup edits for public comment?
I'll also move. Am I allowed to so move? As a chair, does it matter? Vice chair thing?
So it's only that it was only the chair, but actually that rule no longer applies. So we switched over to Rosenberg's rules from Roberts, and the chair is allowed to make motions, but it's not encouraged necessarily. So.
Okay.
But as vice chair, Brandon, those rules I don't think apply to you.
Okay, so I so move.
Second.
Okay, this vote is to send the revised 8.3 out for our 30-day public comment. Bacon, Brown, Bradley, Chivers,
Yes.
Krieger,
Yes.
Mercado,
Yes.
Munoz, O'Reilly,
Yes.
Poindexter, Star, Benola.
Yes, sorry.
Star, Hunter. Okay, thanks, Hunter. And Benola.
Yes.
Okay, so that's 6
I don't-
yeses.
Yeah, I don't think we have a quorum
Do we?
because Justin was here.
Text him.
Let's see if I have his number.
I can email him.
For some reason, I don't.
I'm
gonna just try to quickly go on mute and try to call him just to see.
He was here just a minute ago, so.
We have to hear Justin's response with our own senses, though.
By the way, is there any way to add me to the working group? Would it be too big at that point?
I'm looking into it, Hunter. Hold on.
I believe we have 4 currently, Mimi.
You are correct. We do have 4. So yes, we could add him. Yeah.
I would like to be added if nobody objects to that.
Okay, and make a note of it for the next
Mhm.
assignment agenda.
Okay.
Not necessarily the next, but the next time it comes back on the agenda.
So I unfortunately could not reach Justin on his phone.
It looks like he's coming back.
Oh, good.
But I think he just actually, I emailed him and he raised a good point, is that he's not a voting member anyways.
Oh.
Yeah,
We need to call Joel maybe.
sorry.
Or Vakita was on earlier too, if she's available still.
Do you want me to try to call Joel?
Yeah, I think that would be good.
Hold on.
I'll email him too.
Does
Maybe.
somebody have to vote in the meeting, or can we like put them on a cell phone and just have them say what their vote is? We can get a hold of
They
somebody.
can call in, yeah.
Okay.
Oh, and then what did Bill had to, oh, maybe Bill, he had to take his son to a doctor's appointment, but that was at 2:45. So maybe he's available again. So.
Joel's coming back right now. He said, give him 2 minutes. Hello?
Thanks, Mimi.
Oh, okay, I wasn't sure because nobody said anything.
I think everyone's just trying to contact.
He said he'll get on, he just needs 2 minutes to log back on. Although technically, I think maybe we should put the proposal back up.
I'll put it back up. I see Joel online. Do we just take his one vote, Mimi, or the whole thing
Oh.
again?
That's an Erica call. I think we could.
Can you hear me?
I think because he'll need to hear the motion, I think we should perhaps.
Yes, Joel, we can hear you.
Just 1 second.
Erica, I'm sorry, what did you say?
I think we should just go ahead and retake the vote. Just so
Okay.
Okay. Can you hear me?
Yes.
So we can use the same motions in the seconds.
Can they restate them?
Joel got a chance to actually review it.
I'm trying to, everything seems to be on. Joel, can you hear us? Hello?
He can't hear us. Tell him to go to the chat.
I figured it out. Okay. Sorry, it was hooked up to the wrong computer and everything.
That happens.
What am I voting yes on?
Exactly. So I think, if Joel wants an opportunity to review, and then if the motion could be restated.
Okay. Were any substantive changes made after I got off of
That's what I was trying to remember exactly when you left, so we could just kind of summarize the ones. But I think we were at the stage of editing the comments when you left.
Yeah, run down the comments. I've got 1, 2, 3, 4 I'm okay with. Wait, what's 5?
So they were separated out. So that actually may be something, Joel, that you would
All right.
So
every
report may also be made to appropriate. Okay, good. 6, failure to report. Huh? Okay, all right. Communication state power crime. Okay, all right. Wait, go back up to 4 just to make sure that was the one I was okay with. Yeah, I'm good.
Perfect.
Okay, so we're gonna retake the vote to have 8.3 go out for a 30-day public comment, and then Brandon and Cassidy, if you can restate your motions in seconds, I'll retake the vote.
So do I move for the vote now, or do you need to read it first? Or?
I think you can move.
Okay, I move to approve for public comment.
Second.
Okay, I'll take the vote. Bacon, Brown, Bradley, Chivers,
Yes.
Krieger,
Yes.
Mark,
Yes.
Mercado,
Yes.
Munoz, O'Reilly,
Yes.
Poindexter, Starr,
Yes.
Benola.
Yes.
So the motion passes with 7 yeses, 0 no's, 0 abstains.
Wow, congratulations. I feel like a House member being called back to Congress there. Okay, anything else?
I think it's now 4:30, and that concludes the meeting. I don't know in terms of I guess next steps. I guess you'll communicate with the working group, right, Erica, about the public comment process. So
yes, that's correct. So I'll communicate with the working group as far as a date for the public hearing, and I'll inform them when the item is posted for the public comment. It'll be on the early side of next week, just because the process requires it. And thank you everyone for your very hard work today.
Okay.
yeah, I'm glad we were able to really make some substantial revisions. So thanks,
All right,
everyone.
Thank you.
Bye.
Bye.
Everyone.